just wait and see. Otherwise, if you own a residence, a dwelling, you're going to be strictly liable for any violations that are proven. I may also modify the decision of the code enforcement officer as to the time for correction contained in the civil violation notice, even though said time is rebuttably presumed to have been reasonable. I have this authority as part of being a special magistrate to assess and order the payment of civil penalties and fines, to issue orders having the force of law, to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In the order to make a finding upholding the code enforcement officer's decision, I'm going to have to find that there is substantial competent evidence that the named violator was responsible for a violation of the relevant section of the code as charged. If I affirm the decision of the code inspector, my order will specify the amount of the civil penalty, the administrative costs of the hearing, not less than $100 if assessed, and the date by which the violation must be corrected and complied with to prevent resumption of a continuing violation, penalties of any. The bottom line is that you'll be given time to comply with the violations. If you comply, that's fine. If you don't, then you'll be subject to a per diem or daily fine in the amount of $50 a day, $100 a day, up to $250 per day for a first initial violation. If it's a repeat violation, I can go as high as $500 a day, which happens infrequently, but that's a possibility as well. Again, if you are found guilty of the civil violation charged, you will be assessed an administrative fee of $100. As I mentioned, the city will go first in presenting their case in all instances, and the alleged violator will present their case thereafter. I'll consider the evidence and render a decision after all arguments are heard. So that's, going through that for those of you that have been here before, if not, this is your first time. I just wanted to go through that as I'm required to do. This time, we're going to take roll call for the people of the city that are here. So I'll defer to our town clerk here to do that. Okay, do you want to do it?
No, we just state our names individually.
All right.
So
Go ahead.
Chief Code Enforcement Officer JOSELINE RAMIREZ.
Code Enforcement Officer Eric Richwagen.
Building Official Miguel Nunez.
Harry Hippler, Special Magistrate.
Record Specialist Warner Chavez.
Code Clerk Mary Curry.
At this time, I'm going to adopt the minutes for August 19th, 2021. I'll do that. I've reviewed them, I think yesterday or before today as well as today, and I'll go ahead and approve those minutes. As to the adoption of the agenda, are there any deferrals, additions, deletions, or modifications?
Yes.
Okay, please, go ahead.
Chief Code Officer JOSELINE RAMIREZ. I would like to remove case 6059 as they have become in compliance as of yesterday.
Great, okay. Anything else, or is that the only one? No. Okay, if during the proceedings it turns out there's another one, just feel free to state that later. At this time, I'm going to swear in all witnesses who have placed their name on the sign-in sheet. And if you're going to testify, I would please ask you to raise your right or left hand, depending, so you can be placed under oath. Okay. Swear or affirm to tell the truth, the whole truth, and nothing but the truth. If you could please affirm.
I do.
Great. Thank you very much. Okay, we can proceed. First with the lawyers, all right?
Okay. Case 6544.
What page is that on, if you'd be,
It's on page 2.
page 2, great. Oh, there you go. Okay, Quintero Brothers, formal hearing, I believe.
Yes.
Okay, please proceed, thank you.
Chief Code Officer Jocelyn Ramirez, case 6544, property owner Quintero and Brothers LLC, property address 4908 Southwest 36th Court, Pembroke Park, Florida. A violation was issued on November 19, 2021, by regular mail. On November 30, 2021, a notice of formal hearing with a copy of the notice of violation was sent out certified mail on January 5th, 22, and posted to the property on January 6th, 2022. That hearing was canceled. Therefore, a notice of formal hearing with a copy of the notice of violation was sent out. Certified mail on February 2nd, 2022, and posted to the property on February 3rd, 2022. The violations were for interior renovations being done without a building permit. The property owner had to obtain plans, permit inspections. This is a repeat violation. And as this current time, the owner did try to obtain a permit through a contractor, but that permit is expired, so now they have to restart. So they are working on it. My recommendation is, since this is a repeat violation, is to give them 45 days, if not a $250 per diem with a $100 admin fee.
Yes, sir, if your name for the record, please, sir.
Jorge Gonzalez, attorney on behalf of the Quintero brothers.
Yes, okay.
What she's saying is correct. The thing is that they had a permit back in September, which was being processed. Unbeknownst to them, the architect had let it lapse because there was a number of problems. She was to be here on the 19th, which was the hearing that we had last time, but to explain what the problems are with that permit. She couldn't come today. She has a court hearing today. So what we would ask, there's a number of problems with the permits, and that's that the city has no records of the interior of the property. So they've had to rebuild plans for the whole property, and they've had to go into the property and check to do correct plans. What we're asking for is 45 days is a nice amount of time, but we're asking for 90 days because it is a very complex matter. And these plans have been rejected. They have been presented numerous times and have been rejected because there's a number of problems with the property. So we respectfully request 90 days to be able to comply.
The city's position,
Okay, I'll try to work, but this would be the final. There won't be no extensions after that.
okay, I could go with 60 days.
Oh, it is pretty extensive, so I'll agree to the 90 days, but after that, there's no extensions.
Okay. Just keep in mind, if this is a repeat violation, the town can go up to $500 per day. So basically, they're really being very congenial to you. I'm not castigating anybody. I'm just suggesting that you need to get this, your client needs to get this taken care of and the like. So, all right, I'll go ahead. Based on the testimony, the evidence, and the compliance officer, I'm going to find there's substantial competent evidence to support the town's position. You'll be given 90 days in which to comply, or it'll be $250 a day thereafter.
Thank you.
Okay, let me go ahead the order, and you can start within 90 days, and then I'll sign off on it. Go ahead and call the next case. But there's also a $100 cost assessment. The gentleman hasn't, oh, there you are. Okay, Dave, thank you.
Got it? Good morning. My name is Miguel Nunez. I'm the building official for the town of Pembroke Park. At this point in time, I would like to confirm the fines for the property address at 2000 Southwest 30th Avenue. The owner is BKI 95 LLC. And this is as a result of the non-compliance. Just to give you the times, in October 7, 2021, the notice of violation was submitted to the property owner with the,
Excuse me, Miguel. Where
Yeah.
is the case number?
I'm sorry, 6394. I apologize for that.
What page do you happen to know?
I have that in 305.
What's the, okay, was it 9.5, 9.4, or what on there? Agenda,
Yeah, that's the last case.
BK one, okay, 9.7, okay.
Huh? I'm starting with this one. Oh, do you want me to start with the other one? Okay. Okay, you have time? Okay, perfect. So I'm gonna switch cases. I'm sorry.
That's okay.
All my cases, Mr. Magistrate, are in page 305, and I'm gonna be presenting in one after another.
Great, okay, super.
That makes
Oh,
it simpler for everybody to
Yes.
follow the cases and the process.
Yes, okay.
Yeah, I need
Sir,
a number.
Are you, you're not a lawyer, are you? Are you a lawyer?
Myself?
Yes.
Yes, I am.
Okay, he's another, are you gonna call his cases?
What case is yours, sir?
I believe our case is number 6302.
Yeah, that's the one that I'm gonna be calling right now.
Great, okay, I just wanna make sure because you had, you basically had lawyer written all over you, I could tell. I'm kidding, all right, so, you,
Either way, it's okay.
okay, all right,
I'm a winner either way.
good,
Thank you.
okay, great, okay.
Thank you. I'm sorry, I'm gonna switch cases, I'm sorry, is 6302? Because I need an information on the other one. Yes, again, my name is Miguel Nunez. I'm the building official for the town of Pembroke Park. This is case 6302. This is a case for confirmation of fines. The property owner is Crosswind County Line LLC, and the site address is 5525 Southwest 41st Street in Pembroke Park. This is a violation for the recertification of the 40-year building safety inspection that was not completed on time, even though we have in the September 20, 2021, the notice of violation was issued. The notice of formal hearing with the notice of violation was issued on 10/5/2021 with a hearing date of 10/20/2021, which at that time there was issued the final order. As of today, there has not been in fully compliance, which is needs to be in complete compliance, and that's why we're here on this hearing at this point in time. All the formal notification has been performed either by certified mail or and also posting on the properties.
Great,
So at this point in time, the amount that they have at this point in time is $22,350, and it's still accruing.
that's at $100 a day, yeah,
No, that's
$250.
$250 a day.
Gotcha. Okay, come on up, and if you could, please, just state your name and your representation of who you are representing as well.
Yes, good morning. My name is Neil Eckert. I'm an attorney here in Hallandale, Florida. Good morning to you, Mr. Magistrate. Good morning to city officials. My client was unaware of the 40-year inspection, but was reminded of it with the tragedy happening at the Champlain Towers, which I think we're all aware of, back in the first half of 2021. At that point, he immediately tried to hire an engineer. This was well before he received the violation notice from the city of Pembroke Park. He endeavored to hire an engineer to begin his 40-year inspection, realizing, of course, the importance of such an inspection. It was very, very difficult for him to obtain an engineer. He went through some, I believe, either 4 or 5 different engineering companies, finally was able to obtain an engineer right around the time that, I think actually even before he received the notice of the violation from the city. He has not stopped for one day since that engineer was retained. It's my understanding that at this point, thank goodness there were no safety violations that were produced by the engineer. But at this point, he's spent close to $140,000. I understand the 2 violations concern the roof and some electrical violations, it's my understanding. And at this point, he has those permits having been pulled and having the inspections complete, is my understanding as well.
That is correct.
So I would respectfully request that Mr. Magistrate and the city abate any fines. He's more than happy to pay the administration fee. He's had that building for over 20 years. I understand he has had some notices of violation, never which any of them resulted in a fine. He's always complied with the city's requests. He's been here a long time, serving the residents of Pembroke Park, and we're begging for the indulgence of the city to abate that fine. Hopefully he's in compliance, and everything that the city has asked for has been produced, and that's our position.
Okay, response from the city briefly.
Yeah, unfortunately, the 4-year safety inspection is still not in compliance. Yes, some repairs were done and some repairs outlined into the 4-year safety inspection are compliant on some of them, but we still have to have the engineer final report and certification for use and occupancy, certifying that the entire building is complete, and that has not happened yet. That's not a form, sir.
It was turned in on Monday.
That's not a form. Needs to go back
So,
again.
I mean, a letter with stating that from the engineer is not
No, sir.
possibly used as a substitute for a formal form.
That's a formal form as required by the Broward County Board of Rules on Appeal, sir. It's mandatory that we use that, and all the engineers are aware of that if they are in the process of 4-year. That's the reason why when we send you the information, it's even in our website and it's even in all of our correspondence. It's mandatory that we use the actual form from the Broward County Board of Rules and Appeals.
If I may respond?
Sure, please.
It almost seems as though this is sort of a discussion of form over substance right here. I do see this engineered letter, which you're saying is not the form that's required by the county.
That is correct, sir.
But ideally, the work's been done, the safety has been secured. My client, I'm sure, will do whatever it takes to get whatever form Broward County is requesting, but I can't imagine that anybody would say he hasn't shown good faith in trying to get all of these things done at great expense as expeditiously as possible, given the incredibly difficult climate with the pandemic, everything else, all the unfortunate things going on. So I would beg the city's indulgence that you give him a little bit more time to get whatever form you want done, but certainly the work's been completed, the engineer has signed off on it, the building is safe. I would hope that's what the city is most interested in, and that if this is a formality, please give him enough time to comply with your request that it's done on whatever form. Again, I'm not familiar with the Broward County form or the city form, but I'm sure this engineer will be happy to fill that out and timely supply it to the city as quick as possible.
Yeah, let me cut in here because I can see where everyone's going. What I'm gonna do is this, basically these cases, there really isn't any discretion on my part to stop the fine from accruing until the fine is formed, is filled out and completed. But what you can do after that happens, first what you can do is get the engineer to fill out the form properly and send it to the city, either hand deliver it or by email if they accept the emails, and attach your letter that has a date on it. That's the first thing. Secondly, what you'll be able to do once there has been compliance and there's been verification of this, you can come back for what's called an abatement or mitigation or reduction. And the city is very liberal in granting that. Now, that doesn't mean that your client's gonna be able to walk away from any fine. That's not gonna happen. At least, you know, it's my position as a magistrate that rarely do I even consider that type of an argument. However, they can come back and usually the city can reduce it or does 50%, 80%, 90%, but you just need to get the form, the right form in the hands of the town. And if you can do that today, fine. If you can do it tomorrow, but attach your letter so that you can come back on a mitigation or abatement down the road and argue that it was a form, so, you know, maybe exclude those days. It depends on what the facts are, but I know the city is very flexible in that regard. But get it taken care of. You and your client have worked very hard. You're professional. You've done an excellent job in presenting your client's case. He's here as well. But just get it done, that's all. Form or not. Yes, you have a question?
Yes, to start with, when I came here for the hearing in October, for the scope of work that had to be done from what the engineer wanted, 30 days was completely
Unrealistic.
unrealistic to hire a roofer to do 2 roofs and electrician to do, you know, work on the ACs on the roof. 30 days that was given to me to do it, it was like impossible just to even find somebody who had the capability to do the work that fast.
Okay, but like I said, there's going to be a principal sum that's going to be determined, and you can come back on a reduction motion, hire your lawyer to argue for you, make sure you're here, attach any documents that you have to that reduction.
Is that form available here at the building department?
I don't know if it's you mean for the reduction?
No.
No, the proper form that I think Mr. Nunez wants us to utilize. Can
Broward
he pick
County.
that up here?
He can pick it up here. He can do it it's in our website. When you go to the building department forms, you're gonna see that 40-year safety inspection is right there. And it's also at the Board of Rules, Broward County. It's most municipalities, including ourselves, we use the same form, and it's part of that.
Easy. That makes it
And-
much easier,
okay.
yes.
And just for the record, Mr. Magistrate,
Yes.
this case was initially requested in 2016.
Okay, great. Okay, regardless, you can haggle about that down the road in the reduction.
The thing was, this notification in 2016 supposedly was by regular mail. We never received it. And
Great.
to go any further, there has not been one notification, one mailing, one phone call from 2016 up to 2021. Zero communication about this letter that was sent in 2016.
Okay, but what I am,
Just point of reference.
I know, but that I'm seeing here, I mean, the total amount of $22,350 as of a certain date, and I don't think you didn't go back to 216.
No, sir, we went directly from the
$1
final order.
Right, exactly. So forget that. Just get it taken care of, all right? Get the form. If you have it hand, well, it's okay, hand now, hard copy, just get it. Get it done today or tomorrow. Attach the letter and then see what happens, all right? And get a confirmation that you've complied with it, all right? Okay? All right, based on the testimony you have, somebody go ahead and enter a supplemental order for the code enforcement fine, and I'll confirm the fine. At this time, if there's a lien, I'll do that as well. It'll be $22,350. There's a mandatory $100 administrative fee. It'll continue to accrue until there's approval by the city at $250 per day. All right? Just get it taken care of. All right?
Mr. Magistrate,
Yeah.
can I ask you why you wouldn't extend the imposing of that fine for 2 or 3 days, if we're going to walk upstairs right now, get this form, hopefully have it back, why even impose the fine if ideally, in other words, could we have another hearing after this for the imposition of the fine and possibly an abatement of the fine at the same time? Or are you bound to impose it today?
I have to impose it today.
I see.
And
Okay.
that means it's not something I have discretion over.
I understand. I
So-
appreciate you explaining
No,
that.
that's okay, but if, correct me if I'm wrong, but the town does reduce these substantially in an abatement as well as these. Okay, the answer is yes, so get it done today or tomorrow.
Understood.
All right? You know,
And Mr. Nunes, if I may, can we go upstairs and just get a copy of that thing so I have one as well, and just do it as expeditiously as possible? Can we go up to the building department right now?
Yes, you can go, it's right here, the building department. You need to
Beautiful.
go outside and go to the front door and ask for Lucy or Jeffrey. They'd be
And-
more than glad to help you.
And we're asking, what precise form are we asking for?
Just the 40-year safety inspections, that's it.
And they'll know what it
And
is.
they will give you the whole everything.
Beautiful. Thank you very much,
Thank
both of you, for your time and taking the time to explain this.
thank you, good luck to you, take care of it, we'll see you later perhaps, see how it goes, all right? Later, meaning in the future, okay? Thank you, take care of yourselves, be safe.
Okay, Mr. Magistrate, my name is Miguel Nunez. I am the building official for the town of Pembroke Park. At this time, I'm presenting case 6394. It's in page 305. And this is a case for imposition of fines, and the confirming the fines, I'm sorry. The property owner is BK I-95 LLC. The site address is 2000 Southwest 30th Avenue, Pembroke Park. And this is in regards of a recertification of the 40-year building safety inspection. The initial request was in 2018, but it was never performed. So in October 7, 2021, the notice of violation with the notice of the formal hearing was issued. The hearing was held in November 17, 2021. In the November 17, 2021, a final order for compliance within a certain time and $250 per day. After that, there's no response, no certification, there's no submittal to us. Therefore, right now, we are here. On this case, all the certification has been either sent by certified mail or posted at the property, and posted at the property, both, for perfection of the property. At this point in time, this case has currently $19,100 imposed, and obviously still accruing until compliance of $250 per day. If you have any questions, I'm here to answer them.
I'm going to introduce yourself, if you'd be so kind, thank you.
Good morning, Your Honor. My name is Alexander Carlos. I'm the proprietor of the said property, and I'm here to basically represent myself, along with my attorney, Max Lagan. And this building, for your information, if you will, it was purchased about 7 years ago, and 40-year certification, as far as I recall, took place during the transaction. Now, the 40-year certification, apparently between 7 years and now, maybe enlighten me, I'm not aware of. Other than that, there are some, I don't know if we're discussing other items pending in the building. For your own edification again, Your Honor, this building is not a commercial building. We are in a restaurant business in the Tri-County, predominantly in Aventura and Bal Harbor. And the usage of the building is simply and plainly our own use. We store our own equipment. All implements that we're using in performing operations, you'll find them in there.
Okay, can I just interrupt?
Please, sir.
If I may, and I'll let you say whatever you want, relevant stuff in your counsel as well, but this is a recertification. It's a 40-year recertification. It doesn't matter unless I'm mistaken, whether it's dwelling, whether it's business, or anything along those lines.
Yes, sir. According to the 40-year safety inspection, it only applies for building in excess of 3,500 square
Okay,
foot.
all right.
Single-family residence, townhomes, and duplexes are not included in there. Therefore, this is property, regardless of the ownership and the use, requires a 40-year certification. And in response to what the property owner is mentioned,
Right.
he may have a 40-year inspection back then. Unfortunately, there is no time allowance, because if they did it at 45 or 46,
Right.
it's not 10 years after that. And the safety inspection is 40 years and then 10 years after that. If he maybe have performed a delay 40 year, that still doesn't grant them any time after the 50, 60, 70. It still needs to be done at the specific time, as mandated by the Broward County Board of Rules and Appeals, and as determined by the Broward County property appraisers.
So there you have it. See, when I come to these hearings, I like to listen. I get educated as well. So it is going to apply to you. So, whether you've had it for 7 years or 70 years, you're the owner and you're going to have to take care of it. So what have you done to move this along?
My contention, Your Honor, is that I'm under the impression, as I expressed, that once I purchased the building and I had the 40-year certification, why should I go through that expenditure again? But if you say so, I have no issue of complying.
Well, if you had it, where is it, the 40-year? I mean, is that going to, I don't think, that's not going to matter.
That's not gonna matter, because that was the previous one, needs to be every 10 years or
Right.
at a specific time after that.
So you're the owner of the property, so you need to get it taken care of.
Okay?
The quicker you do it, the per diem will quit earlier, all right? The per diem fine, so you just need to take care of it, all right?
Certainly.
So find an engineer and get it done as quick as you can. I don't know if you were here in the prior hearing or not. If you were you here at the prior hearing that
No,
was just?
sir.
Okay,
All right.
it's the same
Absolutely.
rules, basically. Get the form, hire an engineer, get the form, have them go on board there, take a look at it, come up with, if there's safety issues, take care of them. When that's been taken care of and that's been confirmed, then the fine will stop, okay? But you need to take care of it, really, okay?
Sure.
I mean, this is just, it's critical to the safety of every building, all right? Not that yours is gonna wind up taking the same thing that happened in Surfside or wherever it was, and so, but you need to take care of it. It's, the state has a compelling interest to comply with this, make people comply, and so does the town, okay?
Understood.
All right.
Understood.
Go ahead.
I'm sorry. You go ahead, sir.
No, does your counsel have anything to say, or, no?
Your Honor, on a separate matter, we've been moving this court to listen to our request to rehear a case that we defaulted on. I don't know where that is, but I'm asking this court, when it can, to please listen to that. You and I had a conversation about the Fourth Amendment last time, and I'd like
Oh,
that
okay,
to be heard at some point. But that isn't this case. This is about the fine. Go ahead, Alex.
All right, so this is the fine. You were here on that Fourth Amendment issue, I think, where, let me see, you said that somebody went on the property and then there,
It was an improper entry, yes. Your
okay, that was your position, and then I think that the pictures were taken from off the property, perhaps, and/or.
No, Mr. Hippler, this is actually another case, but we'll discuss it later, as we're
later,
not here
okay,
today
all right.
to discuss that
That's not
case.
today's case.
Okay, all right, so, I mean, I just, I thought, if I can recall,
When the court hears it. Thank you, Your Honor.
okay, go ahead, sir.
In reference to the fine, Your Honor, my opinion, it will make no sense for me to spend $19,000 as opposed to spending probably $3,000 or $4,000 if I hire an engineer and do that certification. I estimate it will cost me less than $5,000. Now, why should I pay $19,000? Of course, the rebuttal to this is that I did not comply. So one of the reasons I'm here is maybe to consider the fine, the extent of the fine, $19,000.
Okay, so you want it waived, in other words, right?
But that's my request, Your
Okay,
Honor.
that's denied, okay. What I'm gonna do, simply put, is you need to get compliance. The quicker you do it, the per diem will stop earlier. This is across the board, everybody's required to do it, except for residences. If it's more than 3,500 square feet, it's whatever it is there, so you need to take care of it. So that's basically it. So you know what you need to do, and that's where we are for now, all right? So based on the testimony evidence of compliance officer, I'm gonna enter supplemental order, code enforcement lien in the amount of $19,100 plus $100 cost assessment. It'll continue to accrue until there's compliance at $250 per day, all right? You know what the rules are, take care of it, the quicker the better for your sake, all right? Okay, thank you, nice seeing you again, Counselor.
Thank you, Your Honor.
Thank you.
Mr. Magistrate, my name is Miguel Nunez. I am the building official for the town of Pembroke Park. I'm presenting case 6159. The property owner is Lake Villa Associates LTD. The site address is 2300 South Park Road, Pembroke Park, Florida. This is a residential complex apartment buildings, 5 buildings within this particular compound, if you want to call it that way. In August 23rd, 2021, a notice of violation was submitted to the property owner. There was no compliance at that point in time. In October 2021, the notice of violation and the formal hearing was September 17, 2021, with a hearing date of 10/20/2021. And the notice of formal hearing and notice of violation was issued. And the final order was submitted in October 2021. As of this time, the property owner did submit 4-year safety inspection, 1 report for all buildings when they're supposed to have 1 report per building, and then require multiple repairs. Right now, we do not have permits for repairs. We do not have anything, so therefore the case is not compliant. At this point in time, the confirmation of the fines is requested, and I'm here to answer any questions you might have. In addition to that, the current accrual is $22,350.
Is Lake Villa Associates LTD here? Not here? Okay, they didn't sign in, I assume, you know?
No.
Okay, all right, I've heard the evidence, there's been notice of this hearing provided, there's jurisdiction. Based on the testimony of the compliance officer, there's substantial competent evidence, there's violations here, there's no recertification or certification of 40 years. The total amount due as of today is $22,350. It'll continue to accrue $250 per day until there's compliance. $100 cost assessment as well. Thank you.
Thank you, Magistrate. Mr. Magistrate Miguel Nunez, I'm the building official for the town of Pembroke Park. At this point in time, I'm presenting case 6297 for the confirmation of fines. The property owner is 2400 Southwest 30 LLC. The site address is 2400 Southwest 30th Avenue, Pembroke Park, Florida, 33009. This is in regards to the recertification of the 40 years building safety inspection that has not been completed in accordance to the code. And in September 2021, a notice of violation was issued. They did not come in compliance. The formal notice hearing was issued in October 5th, 2021, for a hearing date of 10/20/2021. At that time, a final order was issued for $250 a day until the violation maintains, and currently we have not received any kind of information or compliance into this particular process. Therefore, they're not 100% compliant. All the certification, or all the mailing has been either by certified mail or posting at the property. Currently, the accrual is $26,100.
2400 Southwest 30 LLC here. Okay. I listened to the evidence. I'm going to find, based on the testimony and the evidence presented, there's substantial competent evidence to support the town's position. There's been no building and safety recertification inspection, the 40-year recertification. There's due and owing as of today, $26,100, $250 per day thereafter, and $100 cost assessment.
Miguel Nunez, building official, town of Pembroke Park. This time I'm presenting case 6308 for confirmation of fines. The property owner is Hallandale Retail LLC, and the site address is 2940 Country Club Lane, Pembroke Park. The initial request of this particular 40-year safety inspection was performed in 2017. By September 22nd, a notice of 2021, a notice of violation was issued. On October 5th, 2021, a notice of formal hearing with a notice of violation was reissued for a hearing date on October 20, 2021. The final order was issued on October 20, 2021, and at this point in time, we have no communications or no compliance for this 40-year safety inspection has been provided. All the deliveries, all the communication has been performed by certified mail or posted in the property, I'm sorry. Currently, the accrual for the violations are $26,100, and it's still accruing for $250 per day.
Hallandale Retail LLC, are you here? No, okay. I listened to the evidence. I'm going to find there's substantial competent evidence to support the city's position to confirm the fine in the amount of $26,100, $250 per day hereafter, thereafter, $100 cost assessment and administrative fee will also be tacked on until there's compliance. It'll be $250 per day. Thank you.
Sir. Miguel Nunez, building official, town of Pembroke Park. At this time, I'm going to be presenting case 6392 for a confirmation of fines. The property owners is ANO LLC, and the site address is 1960 Southwest 30th Avenue, Pembroke Park, Florida. This is a recertification of the 40-year building safety inspection. The initial notification was in 2018, and the notice of violation was issued in October 7, 2021, for a hearing date on 11/17/2021. In 11/17/2021, the final order was issued. And at this point in time, we are in non-compliance. We have not received compliance from the property owner. All the communications and for this particular process has been submitted via certified mail and posting on the property. Currently, the accrual for all the violations and the fines are $19,100, and it's still accruing for $250 a day.
Okay, is ANO LLC here? Okay, great. Your name, please, and what?
Magistrate Ryan Arcuri, Senior Vice President of F9 Properties, formerly ANO. We're in the one main item that's still open is the painting and the stucco repair. We're under contract on it, understand the mitigation. So as soon as we're done with the work, the contractor has all the permit information to have submitted. I think we're on schedule for about 3 weeks from now.
Okay.
So we'll have it completed, submitted. And
All right. You said, what ANO LLC, does that own this now, or?
Correct. We did a name change a couple years.
Okay, so what are you known as now?
F9 Properties LLC. It's no ANO's.
Okay, what's on the property appraiser's office?
ANO LLC.
Okay, if that's what's on the property appraiser's office, that's what.
Excuse me, Mr.
Yes.
Arcuri, Mr.
Sure,
Magistrate, can I?
Yeah, sure.
Mr. Arcuri, let me ask a question. You mentioned that you are in the process of performing work. Have you obtained any permits for that particular work? Because now that would be another violation.
Understood. No, we've contracted the painting and the stucco repair. They have the year permits. They haven't started any work. We're just on their schedule at this point. They still have to come in and get their permit from you.
Have you performed by an engineer the 40-year safety inspection?
Yes, which you have a copy of.
Okay, normally, what the process actually work, and an engineer should have guide you through that. Once that report is done, along with a certification for the safe continuance of the building, needs to be submitted to the building department, regardless if you need repairs or not. And then, even though that will not stop the proceedings, but at the same time, we have records, because at the time, we need to make sure that that building is safe.
We submitted that before the last hearing, which you have a copy of. I can resubmit it.
So it's been denied so far, so.
It was submitted as safe. There was 3 items on it that the repairs need to be done.
So they need
We know the
repairs,
permits,
okay,
correct.
thank you.
Everybody's on the same page here, whether you're not or not, you understand.
Appreciate it.
Right, based on the testimony presented, go ahead and confirm the find, there's substantial competent evidence, still having violations. I'll confirm the fine in the amount of $19,100, $250 per day thereafter. It'll continue to accrue until there's compliance, and until you get a report, complete the form the Broward County requires until the town approves all that. And it'll be a $100 administrative fee as well. All right, take care of it. You sound like you are on the right track. All right, thank you very much.
Mr.
Take care.
Arcudi also has another case on the agenda. Do you
Okay.
mind if we hear that case?
Oh, please, please. Whatever is convenient for staff and anyone out there, please.
Thank you.
That's all right. That's quite all right.
That's going to be case 4900.
What-
That's page 4, 11.1.
Thank you. Great.
Okay. Chief Code Officer Jocelyn Ramirez, case 4900. Property owner ANO LLC, F9 Properties LLC, cabinets to go. Site address is 1960 Southwest 30th Avenue, Unit B, Pembroke Park, Florida. Notice of hearing to abate fine was sent out, certified mail, February 2nd, 2022, posted to the property February 3rd, 2022. This was for a violation that was for a trailer that was being used as permanent sign. At the time, the violation has been complied with, so we're here to abate the fine. Total amount of the fine is $7,137. That includes recording fees and the release of lien fees. So my recommendation is to abate that fine by 90%, and it will total an amount of $882.
That would include the recording.
That includes the recording fee of the lien, that was $58.50, and then once we release the lien, it would be $28.50.
Great. Okay, what's your position?
Last time when I came here, the case file, I mean, I'm fine paying the $800, so I'll just leave it at that.
Okay,
I'm not even going to bother arguing.
No.
Me and Inspector Ramirez have gone back and forth on this. I don't think we've come to the best classification on it, so.
right, I mean, would
we'll
you
just go
rather
ahead,
pay?
take care of it. No
Would you
issue.
rather pay $7,137?
I'd rather pay zero, but,
I know,
you know.
look, everybody wants to pay zero, all right, but usually
fine.
that doesn't happen, all right?
Appreciate it.
Okay,
Thank
all
you.
right, good. All right, I'm gonna go ahead and approve that. And how long do you need?
If I can pay it via credit card, I can go pay it right now. If you need a check, I'll have to be back tomorrow.
Okay, 30 days,
No
is that, or 10 days?
30 days.
30 days, okay, within 30 days, all right. Total sum, yeah, within 30 days. Okay, I'll go ahead and grant the abatement to the amount of $882, even payable within 30 days. You're going to pay, but I need to say that if it doesn't get paid, it reverts back to the original amount, so it really is somewhat of a no-brainer. Pay it. Okay, done with it within 30 days. Let me put all this in here, okay? All right, thank you. You,
All right,
you
thank
know,
you so
thank
much.
you for your courtesy as well. There you go. Go ahead, I'm ready. You just keep calling them.
This is the first one. Let me give you a copy of the second case. There you go, sir. Thank you. Have a nice day.
Miguel, you can continue. You have one? You're done? So that concludes all Miguel Nunez cases. And we're going to follow the order of the sign-in sheet. The next case will be 5364.
Good morning.
Morning. Just give us a moment. I'm going to present the case, and then you'll be able to speak your turn.
What page is
That's
this?
on page 1.
Okay, 5360. Oh, there you go. Great, hi.
Hi, good morning.
Good morning, how are you?
I'm Renee Archambault. I'm here on behalf of Trinity
Right,
Broadcasting.
I got you. Okay, and we'll let the city go first.
Excuse me, Jocelyn, can you repeat me the case number?
5364. Chief Code Officer Jocelyn Ramirez, case 5364. Property owner, Trinity Broadcasting of Florida. Tenant Juan C. Torres Ortiz. Property address 3300 Pembroke Road, Lot 449, Pembroke Park, Florida. A notice of violation was given by regular mail on October 1st, 2021. A notice of formal hearing and a note with a copy of the notice of violation was given by certified mail on February 5th, 22, posted to the property January 6, 2022. That hearing was canceled, so therefore we sent another notice of formal hearing with a copy of the notice of violation on February 2nd, 2022, and posted to the property February 3rd, 2022. The violations were for an addition and shed that was built without building permits. The owner was to obtain permits and inspections for those illegal additions. At this current time, there has been no permits pulled for any of the violations. My recommendation is to give the property owner 45 days to comply, if not a $50 per diem with a $100 admin fee.
Okay, yes. Thank you. Could you, what's your position? Yes.
Okay, we've hired a law firm because we're under eviction with that property.
Yes.
And as soon as we complete the eviction, we'll go ahead and cure the code violation ourselves.
Okay, how long do you think that'll take?
I don't know.
Yeah, okay.
Not long. We just, as soon as the attorney is done with the eviction process,
Right.
and as soon as they're complete with that.
Okay.
I'm really not sure how long it will take them to complete everything.
All right, I'm not sure either. I'm not sure about, at one point, this is a RV that's there, or what?
Yes,
Okay,
yes, it's an RV park.
And you need to, I think those are customarily done like a residential. They can be moved easily. So it's not like a trailer or a mobile home. Okay. I don't believe, if I'm incorrect.
Mm-hmm.
So, all right, why don't we, you want more time than 45 days? Because I don't know how quickly the courts move in residential evictions.
I think 45 would be sufficient.
Okay.
I have a letter, if you need to see the letter.
No, what does the letter say? Just summarize it.
Just basically that we have retained an attorney for
Okay.
the situation. So
Great.
I think 45 would be sufficient.
Okay,
absolutely.
just keep in mind that if you need more time, if you do not request an extension of time, the $50 a day will begin to accrue. So if you need more time, if there's a problem that you're having with the individual, then email the code officer or whatever they require, okay? So calendar, is that all right?
Yes,
Yeah,
it is.
okay. Because I know you've been here a long time and you'll get compliance as quickly as you can. All right, based on the testimony you have as a code compliance officer, to find there's substantial competent evidence and support the town's position, you'll have 45 days from today or $50 a day thereafter until compliance is just a $100 cost assessment.
Okay.
All right?
Yep.
Okay, let me go ahead and fill this out right here and begin to call the next case.
Thank you.
I'm fine.
Okay, next case is 5997.
Okay. Change here.
That's on page 4.
Thank you.
Chief Code Officer Jocelyn Ramirez, case 5997. Property owner, Rhodey Eves and Bridget Charbonnet. Property address 115 South Key Drive, Pembroke Park, Florida. A notice of hearing to extend time was sent out, certified mail, February 2nd, 22. Posted to the property February 3rd, 2022. Violations were for an AC enclosure built without permits. However, that enclosure does not require permits according to our building official. So that's in compliance. Concrete steps were built without permits. The property owner has obtained permits for this concrete steps and complied with the completed the permit as of November 18, 2021. So this is just to extend the time, so he doesn't have an accrual fees. The owner was in Canada, so he wasn't able to comply until he got here. And as soon as he got this notice on his door, he immediately started rectifying everything. His compliance date is November 18, 2021. So I am recommended that the final order be amended, and to reflect that we'll give him 1 day from today because he already complied, and that will remove all the accrual fines, and he will just have to pay the $100 administration fee.
Okay, so within 1 day of, so up 1 day of today, all right.
Right, because he doesn't really need an extension.
Right, exactly. I got you. 1 day. 1 day and then 0 per diem. Is that right?
The per diem stays the same.
Oh, I got you. How much was it?
It was, I'll tell you, I have the final order here.
That's okay. That's all right.
It was $50 per day.
Okay. All right. Have any questions?
Hello, sir. Mr. Magistrate, my name is Ivro Lee. I understood almost what Officer Ramirez said. The only thing is that we were in Canada. It was impossible for us to come because of the COVID and the insurance and everything. But we never received any letter back in Canada. And our address, mailing address is in Canada. So at the time, the first thing we did, November 10th, we took care of all the the things, and a week later, everything was done. So if we had known back in August.
But you're not having any fine here. The only cost will be the $100.
Oh, okay, I understand that. I still have the $50 a day.
I know, because you've complied, right? So that's not going to occur.
Yeah, the only thing you have to pay is court fees, which is the $100.
Oh, I'm fine with that.
Okay. All right. You don't want to pay more?
No.
Okay, all right. I got you.
Less would be acceptable.
Yeah, I know. But no, it's a good point, because once there's compliance, and I've seen it done elsewhere as well as here, you grant the extension to a certain date, and the only matter you pay for are any administrative fees.
That's all
But
right.
that's why it has to be done that way, so there's a record. Okay, but that's fine. Thank you.
So we just have to pay at the office on the other side?
Yes, you may leave a check or money order with the building department with your case number. You can speak with Jeffrey,
Okay.
and he'll take care of it.
Right.
Yeah, you could go after.
Thank you.
Good luck.
Warner's gonna give you a copy of your final order. Amended final order.
Yes, sir. Have a nice day. Thank you. Same to you.
Next case is 5735. That's on page 4. Chief Code Officer Joselin Ramirez, case 5735. Property owner Danny LaRouche. Site address 3105 Southwest 23 Street, Pembroke Park, Florida. A notice of hearing to extend time was sent out by certified mail on February 2nd, 22. Posted to the property February 3rd, 22. There are multiple violations on this property. The violations are for camera system, addition, prohibited outside use of storage, removal of demo of the wooden stairs in the backyard. I'm sorry, these items that I'm naming, the camera, the additions, and the wooden stairs removal, these things were done without permits from the building department. Wooden fence built without a permit. Laundry room of storage room was added to the back of the home without a permit. There's exposed electrical wires all over the mobile home. And let me reflect on the record that this case was former officers Teresa Malcolm.
Right.
So I am filling in for this and just following up and helping the property owner. He's requesting an extension to comply with all these violations. So my recommendation is to give them an additional 60 days to complete the permits and rectify every item on this violation.
Okay, and how much per day? Is it 50 or?
It's $50 per day.
Okay, can you tell us who you are for the record? Yes, ma'am, sir.
Yeah, it's almost everything done, but.
Sir, your name.
My name is Danny LaRouche.
Okay, great. Go ahead. And ma'am, who are you?
Natalie
Natalie, same last name?
Levere.
Levere. Okay, great. Go ahead.
Yeah, I need just a little bit more time. Everything is almost done.
Okay, is 60 days enough
Yeah.
time? Okay, you got it.
And I make application for the amnesty.
Amnesty program.
Okay, that's not today. All right, that'll be some other time. So take care of it. I don't think if there is going to be an amnesty program, I don't think that's going to apply to the administrative. Apply to any per diems.
Correct.
Okay, so just get it taken care of so you don't have to file an amnesty. All right?
Thank you.
Okay, I'm going to go ahead and grant the extension within 60 days of today and $50 per day after then. Thank you. Hold off until the order is given to you. Thank you.
Sir, one moment while they hand you the amended final order. Next case is 5330.
Thank you. You're Laura and/or Lazaro Jimenez.
Yes,
Green
that's on
Acres.
page 1. Mm-hmm.
And who are you, ma'am? Your name?
Laura Jimenez.
Okay, great. Go ahead, City.
Okay. Chief Code Officer Jocelyn Ramirez, case 5330. Property owner, Green Acres, Pembroke, MHC LLC. Tenant, Laura and Lazaro Jimenez. Site address, 3100 West Hollandale Beach Boulevard, Lot 504, Pembroke Park, Florida. Notice violation was given by regular mail on August 27, 2020. A notice of formal hearing with a copy of the notice of violation was sent out certified mail on January 6, 2022, and posted to the property. I'm sorry, certified mail on January 5th, 2022, and posted to the property on January 6, 2022. That hearing was canceled. Therefore, we sent another notice of formal hearing with a copy of the notice of violation on February 2nd, 2022, and posted to the property on February 3rd, 2022. The violations were for demolition of ceiling truss without a permit, central AC unit installed without a permit, and installation of shed without a permit. The owner was to obtain permits and inspections for all the items. At this current time, there was a permit, but it's null and void, and now they have to restart, so they're not in compliance. My recommendation is to give them 30 days because it is a safety issue, and a $50 per diem with a $100 admin fee.
All right, ma'am, you stated your name before. You're Miss Jimenez.
My English is not very good. That's why maybe sometimes I need someone who translate me.
Okay, where are you from?
My English is not good.
Where are you from?
Okay, I'm from Cuba.
Okay, you sound great to me.
Okay, that's fine, but sometimes I don't understand.
I understand, but
my English is not perfect, you know.
I think you're doing really well.
Okay, thank you.
That's okay. Go ahead.
I appreciate it. Okay, I don't know what to say. I said that I bought that trailer 2 years ago, and when I bought it, it has the air conditioner in the same place. I did not do anything, and the house for the storage house was there too. It is as old as the trailer that is it was built in 1972. The only thing that I did was to try to fix the kitchen roof because it was a little bit bad. And then I made a demolition on that day, and I didn't really I didn't know that I have to ask for permit for someone to fix something inside the house. That's why it happened, and I presented all the documentation that they asked me for. I presented the plans, the engineer plans, and I gave it to Lucy Mancerola. It was on November 2020. I gave her all the plan, the roof plans from the engineer and all the things that she asked me for, and then I never received any more information, any more a letter, any more citation to come, and I didn't know anything more.
But ma'am, here, has she still not gotten a building permit, or is that pending? Because
Right. No building permit. They have to start new, and the building official did mark this property as an unsafe structure. They did remove the sticker from the building official, so it is an unsafe structure. Nobody should be residing on that property.
is anyone living there?
¿Me puede explicar lo que está diciendo? No entendí bien.
El oficial de construcción, Miguel Núñez,
Ajá,
él marcó esa casa que no está seguro.
ajá.
Entonces, que ustedes removieron el sticker.
Bueno, yo no lo removí.
Bueno,
No sé, se
alguien
cayó
lo
porque-
removió en la casa.
Ajá,
Eso es lo que le dije al juez.
ok.
I don't understand what
Bueno,
Spanish.
yo-
I was just, she wanted to know what I just said to you.
Right, okay, I got you. Okay, so, you need to get a permit and you're requesting 60 days? Yeah.
Sorry,
60
what was-
day- No, that's okay, you're requesting 60 days?
30 days. I'm
Thir-
recommending
you're
30
right,
days.
30 days. All right, ma'am, you need, I've seen the photos there. It looks like it's really unsafe. And, nobody should be living there. So, all that I can say is that you're going to wind up having to get a permit and get everything taken care of.
¿Me puede repetir en español, por favor, para entender bien lo que me están diciendo?
Que tienes que coger un permiso y que tienes que preocuparte de que todo esté completo.
Pero, ¿qué es todo?
Coger el permiso de la ciudad y rectificar todas las violaciones.
Ok, pero las violaciones que yo no hice, o sea, te lo voy a decir en español porque es que quiero explicarme bien. Esas violaciones que me impusieron.
Tengo que traducirte.
Da-
The
da-
violations that were put onto her.
Ok, no sé de qué se tratan, porque es que el aire
She doesn't
acondicionado,
understand.
the air conditioner, I didn't put it. I didn't do anything with that and anything with a storage room.
You bought the mobile home. So now, since you're the owner of that mobile home, you have to rectify what was done.
Yes, but I don't know, I didn't know that it has any problem, because I see in the whole park that everybody have the same storage, the same air conditioning.
We're not here to
you know?
discuss everybody. If you want, you can send your reports in to the administration. But right now, we're here to talk to you about your case.
Okay, yo sé que estamos hablando de mi caso, pero yo pregunto qué tengo que hacer, porque yo no sé ni lo que tengo que hacer. I didn't know what to do.
She's saying that she doesn't know what to do, so I'm going to explain to her
Right,
in
no,
Spanish.
Just explain to her that she owns the property, she's strictly liable for it, period.
Lo que dice que tú
Okay,
eres...
I understand
Okay.
that.
Okay, right.
I am responsible for the ones, and I agree to do the ones that I do, that I must do. But I don't understand what to do. If I have to remove the air condition, to remove the
No, you
the
have to obtain
storage, I don't know
permits.
what.
You speak to Lucy like you did before. You were trying to get the permit. You have to continue that
But
same process.
I already gave
It's
her the
expired.
plans.
Everything that you did is expired because nobody
Expired?
responded. Yeah.
Expire the ceiling.
No, the permit. The permit that you pulled, because there was no communication between the building department or the contractor. I don't know what happened, but the permit is expired. Now you have to restart the permit.
Okay, then I need to bring all the
Documentations to the building
documentation
department.
again. I need to restart the case. Okay, comenzar de nuevo todo.
Mhm.
¿Y dónde están los planos? Porque yo entregué los originales.
You speak to the building department. That's a different department, man.
Yes, but what about the plans that I paid for? And
You have to
I
talk
gave
to the
the
building
original-
department.
the
I don't
original
have
to Lucy.
I don't have your plans. You have to speak to them, okay?
To who?
To the building department. Anybody in the building department will be happy
Where
to
is
help
the
you.
building department?
Right there, next door.
Oh, okay. That's why, because I gave my original plans to Lucy, and I don't know what to do now.
Okay.
Okay.
You got to follow up with them.
I appreciate your help, but give me more time, because I'm a widow man,
okay.
women, and I need to know what
Ma'am.
to do at least first.
What I'm gonna do is, I'm gonna go with the 30 days, and if you need more time, you can ask the city for more than 30 days. But you've gotta move on this, okay? The photos are, they look really bad, okay?
Mr. Hippler, sorry to cut you off. I'm gonna refrain from any extensions, because this has been open since August 2020.
Okay,
That's
all
right.
right, so it's been going on, so you're gonna
Like
have
2
30
years?
days. The best thing you can do is just go out and get it taken care of as quickly as you can, so, and it appears that there was already some prior permits applied for, but they've lapsed or whatever, or they're no longer valid, so she needs to go out and get new ones. I mean, that really
Okay,
is.
Then I have to start the process again, all the process again?
Yes, yes.
Okay, and then I can ask Lucy that she give me the plans again to me, because they have it. I don't know. I don't have it.
Yeah,
And I don't want to. I can't have money to pay another lawyer, another engineer again, because I already paid for that.
Well, maybe you can use the same ones. I don't know, all right? That's not for me to decide here today. The building department or Lucy or whoever it is
Okay,
will
but
wind up.
Can you tell me why it was expired? Why happened too much time without?
Ma'am, he cannot
without
tell you
informing
that. He does not work in the building department. He is here to make adjudication on the
understand,
case.
but
You will have to go to the building department.
Yes,
Let me
but
give you the
why?
contact to the building department, and you will contact them directly and follow up about your plans. This is not the building department. We are discussing your case. You need to comply with the violations. You have 30 days to do that. You've had plenty of time. You had a year and a half to comply with this. It hasn't been complied. You need to get it done.
Okay, but a year and a half, I don't know. I
Ma'am,
don't know why
okay.
it was expired.
Okay.
I don't know.
Thank you. I'm gonna go ahead. Based on the testimony of the city and the respondent as well, I'm gonna find there's substantial competent evidence to support the city's position. You'll be given 30 days from today and $50 a day thereafter, and there's a $100 cost administrative fee as well. You need to move this thing along. You know, it's been ongoing for now probably 2 years, And, you need to stay on top of these things. Go talk to Lucy or whoever it is in the building department. Do it now, okay?
Okay, I agree to start with the whole things, but there is only one thing that I want to say. I don't understand why when we are going to buy a trailer, there is no someone who advise us. Not the administration of the. No one. It's not like to buy a house. When we buy a house, they have to pass inspection. But when we buy a house, it's like buy a car, and I don't understand what is happening. And then nobody give me that answer. I don't know.
Ma'am, I don't know. I just know that the burden falls on the purchaser to go do this, which
It's
is
not
you.
easy to pay for something that we don't understand.
Okay, well, you shouldn't have bought
It is
the.
not that you are compliance with the law, but
know,
I can
but
explain
then
my
you
my
shouldn't have
feelings.
purchased
My
it then
feelings
if you
about
didn't.
that because
Okay.
there are things that are not true, are not really, are not.
Okay, ma'am, I've made my ruling respectfully,
Yes,
and
I
good luck
respect
to you.
you,
No,
and-
it's okay, I respect you, so good luck, let's take care of it,
Okay.
okay? Do it, okay, thank you.
Good morning, Mr. Magistrate.
Good morning.
Page 2, 8.2, case number 6018. I've been sworn in. I'm Code Officer Rich Wagon, representing the town of Pembroke Park. This is case number 6018. Property owner Watson Joseph, property address 3114. Okay. I apologize, correction. The property address is going to be 2301 Southwest 34th Court, Pembroke Park, Florida, 33009. Is that lot? Lot 3114? Subject real property, 3114 Southwest 24th Street. They have been found in violation of adding and installing a new air conditioner without a permit. The notice of violation was issued on 7/19/2021. Regular mail on 7/19/2021. Notice of formal hearing was issued on 1/31/2022. Certified mail 2/1/2022. My recommendation is to give them 30 days. If they don't come into compliance, I recommend a fine of $50 per day.
And are you Joseph Watson?
Joseph is passed away December 26th. I'm Jean Watson. I'm his wife.
Great, okay,
The 30 days recommendation is perfect
okay.
because I received from the electric company. They're going to fix that the 17th of February, that's tomorrow. And the inspection is scheduled for the 22nd of February.
Great.
So 30 days will be fine.
Okay. Based on testimony, the Code Compliance Officer, there's substantial competent evidence to support the town's position. I'm going to go ahead and give you 30 days in which to comply, or $50 a day thereafter. There's also a $100 cost assessment fee as well.
Thank you.
Okay, good luck, take care of it, thank
Perfect.
you.
Thank you. Thank you, darling.
Next case is 5345. That's on page 1.
Yeah, I'm ready, go ahead. Case 5,
Chief Code Officer Jocelyn Ramirez, case 5345. Property owner, Park 31 Street Corp. Tenant, Harold Palencia. Site address, 1979 South Park Road, Pembroke Park. Notice of violation was sent out regular mail September 15, 20. A notice of formal hearing with a copy of the notice of violation was sent out certified mail on January 5th, 22nd, and posted to the property on January 6th, 22nd. However, that hearing was canceled. Therefore, we sent another notice of formal hearing with a copy of the notice of violation by certified mail on February 2nd, 22, and posted to the property on February 3rd, 22. The violations were for no business tax receipt, no permit for the auto lift stations, and no permit for electrical work done. The owner or tenant was supposed to get permits for the work done. At this current time, there is not an active permit, and there is no active business tax receipt license. I am recommending that this get done within 45 days, if not $100 per diem with a $100 admin fee.
Yes, sir.
Yes, my name is Rick Chapels. I'm a construction manager for Park 31st Corp., which is the landlord, and I'm here to help with our tenant, who is here also, to resolve the issue. He did, after the first write-up back in 2020, submit for a permit. It was permit process number 92151, but it voided because the contractor he hired didn't ever respond to the building department's comments. So when we were aware of this, once we got the notification for the official, what was January, the thing that was rescheduled, we went and got an engineer involved, and so now we actually have ready to submit engineered plans for the building department to review, which hopefully will get approved, and then we'll go ahead and get this resolved. 45 days should be good. As a construction manager, I would love to have 90. So see what you say.
Well, would any objection to 60 to cut it, or is that going to be enough time? Because they're willing to comply, which is a step obviously in the right direction. You've been around the block.
This case has been open since February 15, 2020. It's been over a year.
5 days it is.
So the best we can do, I will go with your recommendation, 60 days.
Okay, is that okay? I mean,
Yes. 60 days.
That's 60 days, okay.
That'd be awesome. Thank you.
Okay, and what was it, did you say per day? Did you say?
Oh, yeah, I said $100.
100.
Yeah.
Great, thank you. All right, based on the testimony and evidence, the Code Compliance Officer, I'm going to find there substantial competent evidence that support the town's position. You have 60 days from today to comply, or $100 per day thereafter. There's a $100 cost assessment. Just get it done, all right? Thank you. Good luck to you.
Thanks.
Next case is 5270. That's on page 4. Chief Code Officer Jocelyn Ramirez, case 5270. Property owner 5311 Park Property LLC. Site address 5311 Southwest 25th Court, Pembroke Park, Florida. A notice violation was sent out regular mail on July 20, 2020. Notice of formal hearing with a copy of the notice violation was sent out May 25th, 2021 by certified mail and posted to the property. Final order was issued on June 16, 2021. And notice formal hearing for an extension of time was sent out by certified mail February 2nd, 2022, and posted to property February 3rd, 2022. This violations were for operating business without a BTR, and several items that were done without a building permits. That's new doors, garage doors, window mini split system, new wiring, wood partition. Another item is exterior maintenance. Building exterior needs paint. So currently, the property owner is doing everything he can to obtain permits, but he's having a hold at the Broward County permit place. So we're here today for an extension, and my recommendation is to give them 60 days, but this would be the final extension that they will be receiving.
Okay, yes, sir, what is your name?
My name is Martin Applebaum.
How are you related to 5311 Park property?
I own the property.
Okay, that's a good extent, that's a good extension.
Good start.
Good, sir, go ahead, please.
I purchased the property so that my company can operate within the building.
Great.
We are a construction company, and we are very familiar with pulling permits, obtaining permits, and the like. In regards to the violations, I completely understand that when I purchased the building, I purchased the violations with them. What we are planning on doing, and back in April of 2020, we started our permit process to completely rebuild the entire property. At the time of April 2020, we also had to submit for zoning approval that allows a general contractor to operate there. So we tried to submit everything simultaneously and have the permit in process while zoning is approving our ability to operate there. Zoning eventually approved. The building permit application expired. We resubmitted our building permit application. It went through the application process. The final thing that it needed was Broward County approval for the drainage. Broward County is way backed up, and we resubmitted the plans again simultaneously to Broward County. The plans expired again. Broward County still hasn't approved. As of today, Broward County has reviewed it. They asked for a letter. We provided that letter today, and we are hoping to have Broward County approval. I have been in to talk to Ms. Ramirez, the chief building official, the town manager, because I am in a governmental catch-22. I want to do this work. I need to do this work. You want me to do this work, but Broward County isn't allowing us to do this work until we have their approval. And Mr. Nunez, the chief building official, his hands are tied. He can't allow me to even start the work until Broward County approves it.
When do you think Broward County will approve it?
Truthfully, I couldn't tell you. I am hoping within the next 60 days. And once they approve it, I will immediately resubmit for my permit, which Mr. Nunez says he is going to help expedite.
Okay, how many times have you contacted Broward County? What I'm trying to do is see if you could nudge them a bit, or is that going to help, or will that hurt you?
So, unfortunately, Broward County, Durham, they are not operating due to COVID protocols. They're not operating openly.
Right, in person?
In person or otherwise. We've actually hired an individual who used to work at Broward County to call on his friends to see if he could nudge them along. We're doing, again, as a contractor, we're doing everything that we know we can do. As the owner, I'm doing everything that I know I can do.
Okay, how much time did you request? Was it?
My recommendation was 60 days.
Okay, 60 days, and how much, was it $100 or $50?
$100.
$100, okay. I can see the dilemma that you have, having to deal with another local government, so is this something that you're firm about the 60 days, or would you consider 90 days because of what he's having to go through? I mean, if they can do it quicker, he apparently, is suggesting candidly he'd like to get it done yesterday. I understand.
I am
that.
highly motivated to start this
Okay,
project.
so what do you, or we could go with 60 days. I'm just airing this out.
I
like to
understand.
do this so that
I
everybody has
completely
input.
understand and appreciate this. And I also appreciate Mrs. Ramirez working with me, because she's been very helpful up to this point as well.
Everybody in the town is very fair.
Yes, they are.
So, or we could go with the 60 days, and if there isn't compliance by then, or if there's a hang-up somewhere or a hiccup, you come back for an extension of time,
Well, this would be no more extensions, so I'll go with the 90 days.
Okay, all
and
right.
no more extensions after that.
Gotcha. All right, well.
Thank you.
You got the 90 days, so get it done.
Thank you very much.
Okay, that's
Thank
all
you, Mr.
right.
Ramirez.
Okay, based on the testimony of the evidence of compliance officer, I'm going to find that there's substantial competent evidence to support the town's position. You'll be given 90 days in which to comply, or it'll be $100 per day thereafter.
May I ask one question of you? The work, if you recall the conversation that we had when we were with the town manager and the building manager, the work itself is going to take 180 days minimum to do. But as soon as I get this the permission from Broward County,
Right.
I'm going to submit for permit and begin the work. Would the 90 days cause, at 180 days of actual work, once we start the work and start the permit, would that put on hold any of the 90 days?
No. You will get an accrual fine of $100 per day, but you can come back once everything is corrected. You can come back and mitigate the fines.
Okay. Okay, thank you.
Okay, great. Good luck to you.
Please.
You may need it, but good luck to you. So, take care. Good luck.
Next case is 5485.
Hi. Good morning.
That's page 1.
Great.
Chief Code Officer Jocelyn Ramirez, case 5485, property owner Park Lake Inc., site address 426 Marine Drive, Pembroke Park, Florida. A notice violation was given by hand on December 17, 20, and it was given by regular mail December 21, 20. A notice of formal hearing with a copy of the notice of violation was sent out certified mail on February 2nd, 22, and posted to the property February 3rd, 22. The violations were for trenching without a permit, and started work without permit for the building department. There was an emergency repair of main 6-inch water line under the mobile home that they had pulled a permit for, and it expired. So therefore, they will have to restart the permit and complete it. I am recommending that they get this done within 30 days, if not $100 per diem with a $100 admin fee.
Your name, go ahead.
My name is Bertrand Cesset. I'm the property manager for Park Lake Estates.
Great, go ahead.
So we did pull a permit for that job, and also there was an extension for that permit. We've been trying for the past year to close that permit. Here's a list I can show you of how many times we've tried to close that permit with the town of Pembroke Park. They've asked us for multiple reports, which we all provided. We provided a report from the plumber, which is present in this room. I can testify that the job was done up to Florida code. We've also received a report from an engineering company stating that the ground was properly refilled. I have the owner also of the property here. She can testify that everything is fine. So that's where we are. We've been trying to close that permit. I understand that we've sent many pictures also to show what the job, how it was done and what it looks like. I know you want us to redig, you know.
Building department.
Right, but that's what we're working with, you know. We feel that we've provided everything that the town asked, and well, we would like to close that permit once for good.
And how long is that going to take you, roughly, to close that permit out?
Well, we've tried. We've given you everything you've asked
You've given
for.
the building department everything they asked for.
Right.
Okay.
So what do you need from us?
It would be what the building department needs. What I need is for you to close that permit out. So that's something that you have to figure out with the building department to close that permit out.
But we've been trying for a year, 1 year. I have so many emails back and forth, and we're still at the same point.
So we can schedule a meeting, you, myself, and the building department, and see where we stand. But do you think 30 days is sufficient time for once we figure out what you're going to do? Is that sufficient time to complete everything?
Yes.
Since you're telling me the work was already completed.
It's done.
Okay. So we'll have a conversation to see how we can get you to complete that permit.
Okay. So
Okay.
you will.
Yeah,
be in
after
touch
the
with me?
meeting, I will schedule something with you.
All right.
Okay.
Thank you very much.
No problem.
Thank you very much.
Okay, what I'm gonna do is based on the testimony, the evidence, code compliance officer, I'm gonna go ahead and a final order, give you 30 days in which to comply. There's substantial competent evidence. Give you 30 days to comply or $100 a day thereafter. You did say $100 a day, I
Yes.
think. And there's a $100 cost administrative fee as well. So you have 30 days to comply.
Thank you very much.
Good luck.
Next case is 5902.
Five nine?
5902. Chief Code Officer Jocelyn Ramirez, case 5902. Property owner Art Devco LLC, site address 3181 West Hollandale Beach Boulevard, Pembroke Park, Florida. A notice of formal hearing to extend time was sent out by certified mail on February 2nd, 2022, and posted to the property on February 3rd, 2022. The violations were for 24 AC units that were installed without a permit. Unit 404, a door was installed without a permit. A water heater was replaced on the 4th floor in the laundry room area without a permit. Therefore, the property owner has to obtain permits for all the items. At this current time, the contractor is working on obtaining all those permits, but they need more time to complete everything. My recommendation is 60 days to complete all the permits. If not, a $500 per diem with a $100 admin fee. This is an amendment of the final order, so the per diem fine, since it was a repeat violation,
Okay.
it was at 500.
Great.
And this was a case that was formerly Teresa's Balcombs.
Great, okay. Your name, sir?
My name is Douglas Driver. I represent the owners of the property. I work for a company called Meridian Commercial. We're commercial real estate consultants and
Great,
general
okay.
contractors as well. We've been working on clearing up these violations. We had 26 to begin with originally. 3 under this case. We've cleared 13 of them thus far, and we're getting ready to clear a number of others. We've pulled permits for all of them except for the air conditioner units. The unit 404, we did get that inspected, and Mr. Nunez signed off on that one. We're just waiting on some electrical drawings for the water heater. Just getting it's really 32 AC units, not 24, because they don't know which ones are violated or not. The issue with that is this, it's just a huge number. They want to come in, it's over $100,000 every bid that we've gotten thus far. And it's been awful getting people in there because we have to get them into 32 units, and they have to try to price out all the equipment. By the time they do that, they're doing that for no work, for no money at all. And getting a contractor even show up today is difficult. So it's just been a difficult process, especially going through the pandemic. But we're doing the best we can. We're on our 4th contractor now. Again, it's just with doing all the other violations, we're going to be in this for about $250,000 out of pocket for my client. And just trying to find the capital is an issue at this point because we can't refinance and we can't sell due to the prepayment penalties on the note. So we're working through all those issues, and we appreciate the 60 days. And I was hoping everything would be cleared up well before now, and I apologize that it's not, but we're working diligently to do so.
Is 60 days good, or you need more time?
90 would, by the time we get our last contractor, if he gets us a bid in within a week or two, which may or may not happen, by the time they order the materials, for example, just the fencing material, we got our permit back in early November. We just got our fence in last week. That seems to be the way everything's going.
Okay, so 90 days should be sufficient.
90, not 60. Okay, let me change this. Big project, and they're doing it. Get it done, or else it'll be $500 per day. This is a repeat. Okay. Based on the testimony, I'm going to go ahead and extend the time. This will be an amended order. You'll have 90 days in which to comply, or it'll be $500 per day thereafter. There's also a $100 administrative fee as well. All right?
Thank
All
you.
right, just keep moving along. Thank you. Great.
Thank you.
Next case is 5549.
Good morning. Oh, I'm
Good
sorry.
morning. Chief Code Officer Jocelyn Ramirez, case 5549, property owner VNA Miami LLC, tenant Anoints Body of Christ. Site address 4400 West Hollandale Beach Boulevard, Unit 6, Pembroke Park, Florida. A notice of violation was sent out regular mail March 1st, 2021, and given by hand on February 25th, 2021. Notice formal hearing with a copy of the notice violation was sent out certified mail January 5th, 22, and posted to the property on January 6th, 22. However, that hearing was canceled. Therefore, another notice of formal hearing with a copy of the notice of violation was sent out certified mail February 2nd, 22, and posted to the property February 3rd, 22. The violations are for operating without a business tax receipt, and a tenant built out, done without a permit. Right now, there are 2 permits for that unit, but they are on plan review. And because of those permits not being completed, the tenant is not able to pursue her business tax receipt license. My recommendation is to get all of this done within 30 days, if not $100 per diem with $100 admin fee.
Yes, ma'am, what is your name?
My name is Claudine Thorpe.
A little louder. if you would.
Claudine Thorpe. Claudine Thorpe.
Great, how are you related to V&A Miami LLC, Anoints Body of Christ? How are you?
Anointed Body of Christ is my program. It's an outreach that I have a pantry that I feed people. Like I collect stuff and give out to people food. A lot of people call me. That's what I used to do in Miami when we were looking for a place. We found the place, but I didn't know at the time that I needed a permit for the pantry, which Ms. Ramirez explained to me. Since then, I hired a contractor, and the permit, because of COVID, they told me they couldn't pursue. The permit expired before, and I'm still trying. So they told me they put new papers in, and whatever is needed, I'm going to try my best to get it done. Thank you so much for allowing us sometimes, because I've been trying to contact the city so I can get my paperwork done. It's not my choice to close the pantry and not do it, but I have to get your paperwork done before I can do anything.
Okay, all right, is that, then the time again?
Yeah, are you okay with 30 days, or do you need more time than that?
I think I need more time because the contractor told me that he needed more time for the work.
Did he say how much more time?
He didn't tell me exactly, but he said they're asking him for electrical work. The wall that I have doesn't need electrical work. I don't need permit for electric. It's just a concrete wall to make the pantry like I showed you before. Once I have the permit for that and it's through, I will comply with everything that the city is asking me for.
I don't have a problem with 60 days.
60 days is fine.
At $50 a day or at 100?
$100.
Thank you so much.
Okay, you need to get this thing taken care of. I mean, it's just the way it goes. It's, it's based on the testimony and the evidence of the compliance officer. I'm going to find that there's substantial competent evidence to support the town's position. You'll have 60 days which to comply, or it'll be $100 per day thereafter. And there will be a mandatory administrative fee of $100. So get it taken care of, okay? All right, thank you. Good luck to you.
Let me see the review.
Next case is 5142. That's on page 3.
Thank you.
Yeah. Chief Code Officer Joseline Ramirez, case 5142, property owner Catherine S. and Daniel Fan. Site address 3911 Southwest 52nd Avenue, Building 5, Unit 3, Pembroke Park, Florida. Notice of formal hearing to confirm fine was sent out February 2nd, 2022 by certified mail and posted to the property on February 3rd, 2022. This matter is here today to confirm a fine. The property owner has complied with all the violations on this particular case. The confirmation of fine is for $1,000.
Your names, please,
Catherine Fanfan.
and the gentleman to your left.
Well, I'm his neighbor and friend.
Okay.
And I'm also the manager for, not the manager, I mean the president for the association where we live. I believe we came here before and we did spoke to Miss Ramirez about that issue though. And when we came here before, it was 90 days. It was issued to us. I mean, I think it's a misunderstanding or something. That's why we're here to try to fix that issue. We came here before. Last time we explained to Mr. Ramirez, maybe it's a misunderstanding because, I mean, when we came here, I believe that she said she was going to review the tape or stuff like that. And
Yes, and I emailed Ms. Fanfan, and I sent her the link of the video of the magistrate where it states that the magistrate gave her 60 days.
you have the right.
And I have the email right here that I sent you.
What email you use?
fanfanmiami@aol.com.
Oh, I don't use it by myself, that's why. I don't
Okay,
see
well,
it.
I'll be happy to send it to you on another email, but magistrate did say 60 days on that video. And we have a copy of the final order that says 60 days as well.
Yeah, at first, the magistrate was say 60 days, and I was asking for 90 days, and then he said yes, and they give me
Because,
90
I mean,
days.
Not according to our records, and I'll be happy to send it to you.
we don't want to go back and forth with all due respect. I mean, so we do respect the job you guys doing. It's for this our safety, whatever, and stuff like that. I was here. I witnessed it though. It was 60 days, whatever. I mean, I know it was 30 days at first. Then we come up to 60. And before we leave, we waited. I mean, we say, can we do 90 days? We asked for 90 days. It was 90 days. I mean, I know for sure it was 90 days. I know
They have no record of that. They don't have, if we would have done 90 days, they would have gotten a copy of the final order. They don't have no copies of the final orders of 90 days.
She lost the paper though. We waited here. I mean, I witnessed because I came
Okay.
in. This is the
Sir,
members. I mean,
sir, I appreciate, no, let me interrupt because whatever the order says, I mean, I sometimes, was it me as the magistrate or was it, okay. If I sign an order that said 60 days, it's 60 days. If I sign an order that said 30 days, then it's 30 days. If I sign an order that said 1,000 days, which I would never sign, then it's that amount of days, all right? So the bottom line is that that's the order. You were given a copy, as is customary here, and you said you misplaced it, so it's whatever the record reflects. They apparently, as they have done in the past, to confirm that the order and the verbal statement by me or the other gentleman who's a magistrate is the same, identical. And when that doesn't occur, I think on just only one occasion was there a change. This is not one of those occasions. So I'm going to go ahead respectfully to confirm the fine. You can come back for a reduction of the fine if you like, mitigation, abatement, call it whatever you want.
can we do that today or something?
No,
I mean,
no, I, you know.
To me, I don't think it's, I mean, if you all do respect, I don't think it's fair. I think it was 90
Okay,
days.
well, sir, fair or not, that's the ruling, most
It's just my
respectful.
opinion. I mean, I don't.
I know, no, that's okay. Look,
Because,
I,
mean, it was 90 days.
I
was
don't
here.
hold it against somebody to argue with me, okay? I may sometimes agree with the person, I may disagree, same with the city. You know, we're all humans and the like. So I'm gonna go ahead and to confirm the fine for the $1,000. You have complied. So, you know, if you wanna work something out with the city for an abatement, which I think they usually reduce it by 90%. I don't know if that's.
We
gonna-
don't have a set amount what we reduce it.
Okay, all right, so there is no set amount, and it depends. Sometimes it's 90%, sometimes it's 50%. I've seen it, I think, in one occasion where it's 0%. It really depends on how the person, the violator, the adjudication of the violator, how the violator complies, how long they take, and the difficulty. So for now, I'm gonna go ahead and confirm the fine at $1,000. And it was a $50 per diem, but there's been compliance. There's always a mandatory administrative fee of $100. So you'll need to come back and apply for an abatement and see what happens.
Okay, can we do that? I mean, I'm not saying it now. I mean, as far as for the abate.
Yeah, Ms. Van, please send an email to me, a formal letter requesting the hearing to abate fine.
And one more thing too, though. I mean, if we did comply, I mean, why would we pay? I mean, we did the work, I mean, before. She did the work before. What would be, because we thought we had like 90 days.
I know, but
I mean,
it was erroneous for you to rely on 90 when it's 60 days, all right? Well, look, you admit losing the paper, okay?
It was 90 days. I know I don't have schizophrenia. We're not crazy or something. It was 90
I
days.
didn't, nobody says
I'm
you're
just saying,
crazy.
that's
I
my
understand that,
You know what I
but the
mean? So-
order says 60 days, all right? The order, I mean, if you want another copy of the order, the city will give it to you. If it says 60 days, it's 60 days. If it says 90 days, it's 90 days, but it says 60 days. So I've made my ruling, and be thankful that you have the option to come back for an attempt to reduce it. And it depends on what the city decides, what I decide if I'm the magistrate to listen to this, okay? But I'm gonna go ahead and confirm the fine at this time. All right, thank you very much. Good luck to you.
A formal letter, you have to write me a formal letter requesting for the special magistrate to reduce the fine, to mitigate the fines.
Can we talk to you after, or can we do that after?
And then you explain the reasons why you want that reduction, just like you were explaining right now.
Can we talk to you after, Ms. Ramirez? Can we wait? I mean, we only-
You have to do that letter at home. I mean, it's a formal letter.
Yeah, think before you put stuff in there. Don't just, throw in everything under the sun. If you want to do that, that's up to you, but think before you, and then come up with your statements as to what happened and the like, okay?
Thank you.
Good luck. Good luck. It's okay.
No, it's this one, but, it's okay.
Outside, there's another.
Oh, there was a form outside. Was there anybody there when you signed it?
What is the case number?
What's your name?
My name is Yoni Meyer.
I-O.
And I is in last name is Meyer and Y-E-R.
Didn't sign in, or you did, but somehow you slipped through the cracks.
It's okay.
I know, but look, you got all this experience, all right, watching.
It's totally fine.
Plus, you were doing some work there, which is good.
You
Smart
signed
move.
in? What case?
6168, Amita.
But your case wasn't it heard by Miguel Nunez? He never said your case?
6168.
Number 17 on the second page.
Yeah, he did sign in, but did Miguel read his case? No? Do you still have the order with you, Warner?
No, Miguel not read this case.
That's what I thought, but he said he had concluded his cases. Let me call him.
6168, no, that was not read.
No.
Okay.
I mentioned it to him.
We're sorry about that. He was reading all his cases. He must have missed it. Yeah, me too. I have mentioned to him to finish, and he said he was done. Okay. So 6233.
What number again?
6233. Chief Code Officer Jocelyn Ramirez, case 6233, property owner 3535 Southwest 52nd Avenue, LLC, care of TL Management, LLC. Property address 3535 Southwest 52nd Avenue, Pembroke Park, Florida. Courtesy notice was sent out regular mail on June 12, 20. A notice of violation was sent out regular mail on September 1st, 2021. A notice of formal hearing with a copy of the notice of violation was sent out certified mail January 5th, 2022, and posted to the property on January 6th, 2022. That hearing was canceled. Therefore, another notice of formal hearing with a copy of the notice of violation was sent out February 2nd, 2022, and posted to the property on February 3rd, 2022. The violations are for exterior sign, exterior roof, exterior floor walls, and exterior common areas require maintenance, wash, treatment, repair, paint, etc. Shed that was installed without a permit, wooden fence on back end of the property was installed without a permit. Damaged chain link fence that requires repair. Damaged poles in front of property requires repair. Parking lot requires maintenance, wash, treatment, repair, paint, etc., and a permit to pave and restripe. Also, the monument sign requires maintenance, wash, treatment, repair, paint, etc. The managers of this property have been in contact with me. They are trying to take care of most of these items. I know they've started working on it, but I believe they're having some issues with the contractors, etc. My recommendation is to give them 45 days to complete everything, if not a $250 per diem, because it is a repeat violation, and a $100 admin fee.
Yes, your name and how you're related to 3535 Southwest.
My name is Yoni Meyer. I'm the Director of Operations for a company called 428 Healthcare. Can you hear me?
Oh, yes.
Okay.
Great.
So 428 Healthcare, I know this sounds complicated. I think they're the management group for 3535 Southwest 52nd Avenue. I joined the company in the beginning of December. My job is to run the operations for 10 facilities that they manage. And my approach is and always will be to correct things the right way. Not haphazardly, but the right way. And I will give you one specific example here. Is number 2, the exterior roof requires maintenance. So we received a $15,000 quote to maintain the roof, except the roof is 30 plus years old and really it needs to be replaced. So I consulted with the owners and they've agreed to replace the roof. We have a signed contract to replace 43,125 square feet of roofing. It's a very large roof and structure, but that's the right way, I believe, to correct this. Not to clean it, but then the roof is in still bad shape. It's already in a state that it's past its last leg of its lifetime expectancy. So this was signed by the owners the end of January. I asked the roofer for an update on when he's expecting to file the paperwork for the building permit, and he said within the next week or so it should be filed with the city for a permit. He's expecting the project to take about a month and a half to complete. So specifically for this one, 45 days. I can go through every single one because I'm actively involved in every single one of these that I can tell you an update on every single one of them. We're addressing every single one of them, and again, like I said, the right way, not the wrong way, meaning not just to get rid of the violation, but, so that it shouldn't be a continued issue or a maintenance issue.
How many days are you requesting?
Specifically for the roofing project, I would like, just because roofing is a very complicated, it's not me trying to, there is major supplies, especially that quantity of roofing. So he can't guarantee me a date, and I can't therefore guarantee you guys a date. But we've already made the decision, the contracts have been signed, we're actively working towards the roof replacement. So I'm asking for 90 days with the option to be able to extend an additional 30 for the roof specifically, because that is a large project. Everything else, 1 second, exterior, I just want to verify the 45 days should be good for the other things, 1 second. If I can ask for 60 days, please, for everything. Like I said, we are every single thing. Some permits have been pulled already. One is in the middle of getting approved. I have copies of estimates that have already with deposits that have been paid to the contractors for every single line item except line item number 1 and number 10. I spoke to.
You spoke to me, yeah, it's the same thing.
And that we have agreed at this point that line item number 1 and 10 is the one and the same, so there's really technically only 9 violations here. But again, like I said, the permit for the striping has been, was approved. Damaged poles in front have been removed because I found them, by the way. They were not, I found those poles and they're gone now.
So there are a lot of items he needs to take care of, so we'll just agree to 90 days.
That's great, okay. I was gonna suggest that as well, you said 90.
But for the roof, if you can request possible additional 30 after, because that's a supply issue.
No guarantee. I know based on another matter that I came up somewhere else, that the roofs, the tiling sometimes presents a pain in the you-know-what to get on tight. Depends how unique the tiling is. Hopefully, you're getting the vanilla run-of-the-mill tiling.
It's a shingle roof.
Okay,
I can tell you which
whatever
one.
run-of-the-mill is. I know that if there's unique stuff, it takes longer, but the run-of-the-mill stuff should not be difficult to get, because once you get it and the permitting is permitted, they can put a roof up, it shouldn't take more than 2 or 3 days to get it. That doesn't mean it will be approved in 2 or 3 days. It just means that, they rip the old one off and they put the new one on, and, it.
No, we are, I like to, I hope for the best, but expect the worst.
Okay, good.
That's, there's no reason, we're not delaying this, is everything, we're moving forward, everything is
I
planned.
understand that. Okay, no, what I'll do is, I appreciate your candor and you having to wait here. So we'll give you I'm gonna go ahead and enter an order giving you 90 days for everything. And then, 250, oh, you said 100.
250.
No, 250, I'm sorry.
Per diem.
Per diem thereafter. Your client, or owner, whoever it is, it'll make them push ahead quicker, and you're gonna do that as well, all right?
No, all right, I've taken an active approach since I joined at the beginning of December, and I have every intention of continuing that.
Good.
But again, what's the process to request an extension for specifically the roof only? Just because really the roofing was just, it's a maintenance violation, but we're replacing, so I feel like we're going above and beyond specifically for the
Okay,
roof.
no, I understand that. If you could, down the road, if you're within the 90 days, do not let the 90 days run by. Because if you do, then there's an issue of whether or not the town even has the jurisdiction to extend the time. So you need to put that on everybody's calendar and take it seriously. If it's within the 90 days, state why, what happened, what your position is about what you've done. And this, in the town representative, the code officers are very reasonable. You can see that from what you've seen in these cases. And they'll either agree with you, if not, you'll come back before me or the other gentleman who's a magistrate, and you'll either get an extension or you won't. So that's what you need to do. But the 90, I don't really like to go beyond 60 days. Definitely not 90, and I don't think the city does either. In this instance, it calls for, and you're taking a proactive approach. But there's just a whole heap of stuff here that needs to be taken care of. So, and you'll be enhancing the value of your property as well, as we all know, when you do this. So I'm going to go ahead and give you 90 days or $250 per diem. You know what you need to do, and just go to it, all right?
Okay,
But
thank you.
that's okay, based on the testimony, evidence, compliance officer, I'm going to find there's substantial competent evidence to support the town's position. Give you 90 days in which to comply, or $250 per day. Thereafter, $100 administrative fee. Just get it done, move forward. If you need more time, without prejudice, as lawyers say, without any agreement, state the reasons why, but don't rely on any extension of time.
Understood.
Okay? Just get it done, all right?
Okay, can I just ask, this is
Sure.
my first time, so once we've addressed, I want to say pretty much everything except the roof, who do I contact? Do I contact?
You're looking at the, right there, she's the boss there
Ms.
in that
Ramirez?
department.
When you complete everything, you can contact me,
Including the roof or everything but the roof?
including the roof.
Everything.
So we couldn't get,
You can update me as you go,
Oh, okay.
yeah.
okay, fantastic. Thank you so much for your time.
Thank you, good luck to you, take care.
Thank you. Is there a link I can pay online for the $100?
No, you have to pay in person. We're not there yet. We're getting there.
Almost.
Check our money order, and you can go to the building department and see Jeffrey.
I don't have anything with me, I gotta get it from corporate. So-
All right, so then,
Okay.
yeah, or you can mail it,
Oh, okay.
whatever is convenient.
Jeffrey's contacting me.
Thank you, take care. Sorry about the wait, I think we all that, okay, no, acknowledge that.
Okay, Mr. Magistrate, I'm back.
You're back, all right, action.
For whatever reason, I had to apologize. I have in all my notes here that I read the case.
Yeah.
And we already have that done, but it appears that I was called that it was not.
Okay.
So,
Go ahead.
doesn't hurt to hear again.
Yeah, go ahead.
Okay, my name is Miguel Nunez. I am the building official for the town of Pembroke Park. This is in reference to case 6168 for the confirmation of fines.
Yes.
The property owner is Amira Development LLC, and the site address is 2350 Southwest 30th Avenue, Pembroke Park, Florida. This is in regard to the recertification of the 40-year building safety inspection that has not been completed on this particular property. The notice of violation was originally issued in August 24, 2021. Obviously, in October 5, 2021, a notice of formal hearing for a hearing date of 10/20/2021 was issued. In 10/20/2021, a final order was entered, so the property owner can pay, if he's not in compliance with the certain days, $250 daily. Unfortunately, it has not been in compliance. We have not seen any documents yet. All of the documents were either certified mail or and also posted on the property as a common courtesy. At this point in time, the accrual for this particular fines are $26,100 and still accruing in the amount of $250.
Okay. Yes, sir, what is your name?
My name is Nader Amini. I'm the owner of the Amita.
Yes, okay.
I'm surprised for two reasons. One, we bought this building 2 years ago. Mr. Nunes' portion of this building was built up in 1970. So 40 years was passed already by the previous owner. And the other portion, which has not comes up with the 40 years because that was 1995 or something, has been built up. Since we bought it, I was here also with a meeting during the COVID with my architect who passed away. At the meeting, we tried to bring the new design for the building with Mr. Miller also with the meeting. So we were going back and forth to upgrade the building. Now, also, I just listed to the DoorDash company who's having a lot of new plans and design. We keep upgrading the property. The mailing address was going to 888 Southeast 3rd Avenue. I have a proof of this building sold in April 2021. And about a week or 10 days ago, I've seen the sign posted on the window. Immediately I contact here, the town, and also I put one of my staff called every day and sending a text and calling. No one respond to any of our calls or emails also. But I'm here. I'm part of your city as far as the being owner of the property here. I'm here to do anything I can with my power, hire anyone. All I need is just a little time and start to do the 40 years inspection, which I think you should have it because 40 years was passed before I bought it. And I don't know why you didn't request it from the previous owner of the property, Mr. Nunes.
Allow me to explain myself a little bit of what the 40-year safety inspection actually entails.
Okay, sir.
The 40-year may have been performed many years ago. Now, in accordance to Section 110.15 for the Florida Building Code, Broward County Administrative Provision, which is the one who governs the 40-year safety inspection, the 40-year needs to be performed at 40 year and then 10 years thereafter for any building, regardless of the size or regardless of the condition, if it's more than 3,500 square foot. Doesn't matter how much upgrade you do in the building, doesn't matter how much you present on the building, the 40-year safety inspection is a document that needs to be presented regardless. Now, if the particular owner previously, he did it at 45 years, not because he did it 5 years later, you're gonna have 5 years more to do. It needs to be at the date that it was designed because there's a program that comes from the Broward County Board of Rules and Appeals and the Broward County Property Appraisers. All this information was presented a long time ago, and the address that we have here in Amira and everything comes directly from the Broward County Property Appraisers.
Right.
Information was mailed multiple times to 888 Southeast 3rd Avenue. I do remember the address, and because there was nothing else, even Amira, when we went to sunbase.org, did not show up in the sunbase.org. I don't know if it was owned by somebody else or additional information was there. However, we did, and by perfecting the mailing, it was posted on property in accordance to state law and the requirements.
Correct.
However, a 40-year safety inspection, it is mandatory, it is due, and that's all I can tell you at this point on time.
I just try to cooperate, and I just want to prove it. I'm not trying to walk away with
I understand
and argue
that.
with anything. Just want to prove it. The building, the address was that was mailed is sold, and I wish the post was on the window or the door of the property was earlier, and I will definitely move on and start to fix it. But now I'm here and just ask for some time to start to process that 40 years, even though again, I wish it was done.
I'm sorry, what's your name?
Alireza, that's my birth certificate. I'm the owner of the Amita.
Okay, just to let you know,
Yes, sir.
in October 22nd, 2021, because I'm looking by all the addresses and all the, everybody that is associated with this particular property.
Yes, sir.
Also, a note was sent to Mr. Edward Maslanka, because all that was part of the records, Imperial Lane in Lauderdale by the Sea.
That's not us.
And unfortunately, this is the property appraiser's form where it shows AAA, the mailing address for Amira Development, AAA Southeast 3rd Avenue, and doesn't say anything about that. When you go to Amira, that's all it shows in here.
Can I present this to you?
Yeah, why not? When was this change?
It's the address it says, it's the date of the sale report of the AAA. Again, sir, I'm not here to say you're 100% right. All I'm asking is the time to provide whatever you want. And that this gentleman you said is nothing to do with us. I have no idea.
No, this has nothing to do. This is the site address in Fort Lauderdale.
888, yes, that's what I'm saying.
No. When you go to talking about on this, the site address is in Fort Lauderdale. This is not the property in Pembroke Park.
No. That's the mailing address, whatever we receive for Amita, this building.
Well, it's the same one that we have here.
Yes, but that was sold back in...
No, you're not understanding, sir. You look at here, it says site address,
Correct.
AAA Southeast 3rd Avenue.
Correct.
I understand what you're saying, that this particular property was sold on this time.
Correct.
We don't, this is Fort Lauderdale. We do not go to Fort Lauderdale to verify if that property is sold or not. We go by what we have in our property. If you look at the site address here, it belongs to Pembroke Park, and the mailing address is on this. This mailing address should have been changed by Amira Development within the changes.
100%.
And that never happened. So that's the reason why we feel that we did the proper,
100% you're
But
correct,
that's
sir.
good notice. It's what the property appraiser's office said.
That's
You're
correct.
referring to another piece of property.
That's correct, sir.
Okay, then why even have brought it up? I mean,
I
if-
just brought it up because
if-
that's the honest mistake, honest fault, whatever, which that property, nobody was there to receive those notices.
I know, but
That's
it's,
why.
okay.
That's what I'm
all
trying
right.
to explain.
Okay, go ahead. I've listened to anything else from anyone?
All I need is the time to start
Okay,
to...
well, what I'm gonna do is I'm gonna go ahead and confirm the fine. You'll have time, and I suggest that you do it as quickly as possible, because I'm gonna confirm the fine at $26,100. It'll be $250 per day thereafter
No, sir,
until
I
there's
have-
compliance. It'll be a $100 administrative fee. You need to get this thing taken care of.
I'd be happy to take care, but that's not fair, sir, with that fine, sir.
Okay, but the thing is that there's been good service. That's the first thing that everyone looks at, including me. There's been good notice. What you can do after you comply as quickly as you can is come back for a reduction down the road. And that's the best we can do for now. There's been good service here, and, you know, the rest is up to you, all right? You need to take care of it.
I'm here to take care of it, sir.
Good, all right, anyway, that's my ruling, so I'm gonna go ahead and confirm the fine, the code enforcement fine lien, $26,100, $250 per day until there's compliance, and a $100 administrative fee. And when you get the engineer involved, when you comply with the 40-year inspection, with the right form and everything, you need to immediately contact this gentleman to my left here to get everything confirmed. Then the $250 per day will stop accruing, okay?
What about the fine, sir?
Well, it's gonna continue to accrue until you comply.
What the magistrate, allow me to explain. what the magistrate just told you, I'm sorry, sir, I just want to translate what in those terms, is that after the building is in compliance with 40 years, that after it's in compliance, the day that you become in compliance, these fines will stop. There will be an amount of dollars, and it's up to you to request a reduction or abatement of fines. And then you come in front of the magistrate, and then the magistrate may, at his sole discretion, reduce the fine at certain levels or something like that.
Thank you, sir.
Okay?
Thank you, sir.
But one thing has to be complete before you initiate the other one.
Immediately. Thank you.
Good luck, sir. Thank you.
Thank you, Mr. Magistrate, and I apologize for the inconvenience.
So,
I was.
there's no inconvenience. Don't worry about it. Don't worry about it.
Mr. Hippler, we're going to take a recess.
Could we about 5, whatever.
2-9. Property owner, Green Acres, Pembroke, MHC, LLC. Tenant, Mario Ramirez. Site address, 3100 West Hallandale Beach Boulevard, Lot 21, Pembroke Park, Florida. A notice violation was given by hand on August 25th, 20. By regular mail on August 27, 20. A notice of formal hearing with a copy of the notice of violation was sent out certified mail on January 5th, 2022. Posted to the property on January 6th, 22. And that hearing was canceled, so another notice of formal hearing with a copy of the notice of violation was sent out certified mail on February 2nd, 22. Posted to the property on February 3rd, 22. The violations were for electrical work done without permit, 2 shed installed without permits, installation of AC mini split installed without a permit. At this current time, the tenant has not pulled permits for any of the items listed. Therefore, I'm recommending that this get done within 45 days, if not a $50 per diem with a $100 admin fee.
Based on the testimony and evidence of a code compliance officer, there is substantial competent evidence to support the city's position that we given 45 days to comply, $50 per day thereafter, and a $100 administrative fee.
Okay, following case is 6184. Chief Code Officer Jocelyn Ramirez, case 6184, property owner Edwin D. and Jean Marie O'Toole, business Asphalt Steel Coating Products, Inc. Site address 2111 John P. Lyons Lane, Pembroke Park, Florida. A notice of violation was given on August 27, 2021. A notice of formal hearing with a copy of the notice of violation was sent out certified mail on January 5th, 22, and posted to the property January 6th, 22. That hearing was canceled, so another notice of formal hearing with a copy of the notice of violation was sent out certified mail February 2nd, 22, and posted to the property February 3rd, 2022. The violations were for exterior maintenance of building of the 4 walls and roof, required maintenance, pressure wash, treatment, repair, paint, etc. Damage and unpermitted wooden fence, damage and unpermitted canopy, damage and unpermitted chain link fence, damage awnings, damage and unpermitted carport, overgrown vines on chain link fence, overgrown weeds, dead vegetation, trash and debris on property, and parking lot exterior requires maintenance, and unpermitted business signs. The owner has to obtain permits for all unpermitted work and maintenance the property. At this current time, there has been no compliance for any of the items listed. Therefore, I'm recommending that this get all done within 45 days, if not $150 per diem with a $100 admin fee.
50 or $100 per diem?
150.
150?
Yeah.
Okay. 45 days. Okay. Based on testimony as code compliance officer, I'm going to find your substantial competent evidence supports city's position. I'll go ahead and give them 45 days in which to comply, or $150 per day, or and a $100 administrative fee. Thank you.
Okay. Case 6546. Chief Code Officer Jocelyn Ramirez, case 6546, property owner Edwin D. and Jean O'Toole. Site address 2111 John P. Lyons Lane, Pembroke Park, Florida. A notice violation was sent out regular mail December 1st, 21. A notice of formal hearing with a copy of the notice of violation was sent out January 5th, 22, and posted to property January 6th, 22. That hearing was canceled. Therefore, another notice of formal hearing with a copy of the notice of violation was sent out certified mail February 2nd, 22, and posted to the property February 3rd, 22. The violation was for installation of new wooden fence without a building permit and trash and debris on the property. At this current time, the property owner has not done anything to comply with these violations, and this would be considered a repeat violation based on the previous case I just mentioned. Therefore, I'm recommending that this get done within 45 days, if not a $250 per diem with a $100 admin fee.
Based on the testimony as code compliance officer, I'm going to find there's substantial competent evidence to support the city's position. Give the respondent 45 days in which to comply, or $250 per day thereafter is a repeat violation, and the administrative fee of $100.
Next case is 5021. Chief Code Officer Jocelyn Ramirez, case 5021. Property owner Oscar Munoz, site address 3140 West Hallandale Beach Boulevard, lot 611, Pembroke Park, Florida. A notice of hearing to abate fine was sent out certified mail February 2nd, 22, posted to the property February 3rd, 22. This case has been in full compliance, and so therefore the owner is requesting for the abatement of the fine. The fine accrued to $1,700. And my recommendation is to abate it to $260. And the owner requested that if they can pay within 60 days.
Is acceptable to you? Okay, great, okay. All right, I'll go ahead, and this is an abatement action. The owner is not here, but they're requesting an abatement, which is going to be granted. It'll be reduced to $260 if paid within 60 days. If not, then it'll revert back to $1,700. So payment within 60 days of $260, or reverts back to $1,700. Thank you.
Okay. The next case is 5629. Chief Code Officer Joseline Ramirez, case 5629, property owner Marion N. Simon, property address 5453 Southwest 41st Street, Pembroke Park, Florida. The reason for today's case is to vacate the final order that was entered. Former Officer Teresa Malcolm entered this final order on November 17, 2021. When she entered this final order, the property owner was in full compliance. So my recommendation is to vacate this order.
Okay, we're vacating the order and you've attached it. So, right. Aaron is hereby vacated. There you go, I just signed off on it. Thank you.
The following case is 4866. Chief Code Officer Joseline Ramirez, case 4866. Property owner Warehouse 1800 LLC, tenant Universal Marine. Property address 2401 John P. Lyons Lane, Pembroke Park, Florida. This case is here today because there was a lien entered in error. The property owner, this case, like, it's very antiquated. It's from October 4, 2013. And there wasn't some information missing in this case file where it didn't show that the property owner was in compliance. But after the property owner entered into evidence many documentation that showed that the tenant that was written up for no business tax receipt at the time was actually evicted, removed from the property, and complied in time. They provided all the information, so therefore we want to vacate this lien order that was entered, and that would close this case.
I have a question. Was this error presented by that code officer at the time?
The code officer at the time is James Tisdale, and he's deceased.
Right, okay, I got you. So that was like a long time ago. All
Yeah.
right.
So we weren't able to get his opinion of the matter. So
I got you.
once
Okay.
the property owner entered all that evidence, then we were able to assess, and the town attorney also viewed the case, and we agreed that it should be closed.
Okay, we'll vacate the 4866. There you go.
And that concludes all my cases.
Mr. Magistrate?
Yes.
Page 2, 8.1, case 5996. No problem. Yep, it's going to be 5996. I've been sworn in. I'm Code Officer Richwagon, representing the town of Pembroke Park. Property owner, Yobelver Hernani. Property address 3140 West Hollandale Beach Boulevard, Pembroke Park. Lot 718 is found to be in violation of the following issues. They installed a water heater without a permit. They added a screen room onto the mobile home without a permit. Doors, windows, and roof over to the screen room are additions. That's it for that one. A notice of violation was issued on 7/2/2021, posted to property on 7/2/2021. Notice of formal hearing, notice with NOV on 2/1/2021, certified mail on 2/1/2021. My recommendation for this is 60 days with a fine of $50 a day if not complied.
Based on the testimony and the evidence of code compliance officer, there's substantial competent evidence to support the city's position. They'll be given 60 days in which to comply, or $50 a day thereafter. And of course, a $100 administrative fee.
All right, Mr. Magistrate, this will be case number 6428. I've been sworn in. I am Code Officer Richwagon, representing the town of Pembroke Park. Property owner or owners, Mitza LaCroix, Benson Augustine, and Mary Baranaville. Property address 4800 Southwest 36th Court, Pembroke Park, are in violation of they removed a chain link fence without a permit, the installation of the new fence without a permit. The NOV was issued on 10/15/2021, regular mail on 10/15/2021, notice of formal hearing on 2/1/2021, and it was hand-delivered on 2/1/2022. My recommendation is 30 days. If it does not come into compliance, a fine of $50 per day.
Based on the testimony as a code compliance officer, I'm going to find there's substantial competent evidence to support the city's position. We'll have to comply within 30 days, or else it will be $50 a day.
Case number 6429. I've been sworn in. I'm Code Officer Richwagon, representing the town of Pembroke Park. Property owner is Bertilda Archinold. Property address is 3140 West Hollandale Beach Boulevard, Pembroke Park, Lot 903. They are in violation of removing the AC without a permit. Okay, yeah, so they just needed to obtain a permit for the AC removal and replacement. The notice of violation was issued on 10/18/2021, regular mail 10/18/2021. Notice of formal hearing was 2/16/2022, certified mail 2/1/2022.
Okay, how many days would you recommend?
Recommendation, 30 days, same as prior. If they don't come into compliance, a fine of $50 a day.
Great, okay. All right, based on the testimony you have as a code compliance officer, there's substantial competent evidence to support the town's position. They'll be given 30 days in which to comply, or $50 per day. Thereafter, a $100 mandatory administrative fee.
Case number 6430. I've been sworn in. I am Code Officer Richwagon, representing the town of Pembroke Park. The property owners is Julia Paraffin and Maria Galvan. The property address is 3300 Pembroke Park Road, Pembroke Park, Lot 335. The violations are, give me 1 second. Okay, so they added an addition onto the property without a permit. They added new windows without a permit. They have prohibited outdoor stored items, including trash and debris. No permit for the shed with door installed. The NOV was issued on 10/18/2021, regular mail 10/18/2021. Notice of formal hearing 1/31/2022, certified mail 2/1/2022. The recommendation for this one is 60 days. If not in compliance, a fine of $50 a day.
Okay, based on the evidence of the compliance officer, I'm going to find that there's substantial competent evidence in which to support the town's position. They'll be given 60 days of date to comply, or what did you say, 100 or 50? $50.
$50.
$50 per day thereafter.
Oh, I apologize. This concludes my testimony.
No, no need to apologize, it's all right. Thank you.
Thank you, Mr. Magistrate.
Thank you.
Did you want to discuss that case?
Yes. Yeah, just give me some dates. I don't know if I need to even look at the file. I remember there's a final hearing. I'm sure that I entered a final order, as best I recall, finding a violation and giving them a certain amount of time. If that's the file. Right, okay. Oh, yeah, that's good enough. And then you just need the date of the, did it 1/20/22, supplemental order 3150. Yes, exactly. They go to the Broward County Courts according to the, okay, this is a supplemental order imposing or final order. The final order, I'm talking about Town of Pembroke versus BKI-985 LLC, case number 5700. I'm reviewing a motion to set aside, he calls it a default judgment, whatever, should be set aside because they failed to appear to understandable confusion. Max Lagan signed it. Member of the owner was provided an affidavit of compliance, which Alice took to satisfaction, thinking the violation complied with no appearance was made. Mr. Calvin recognized there are several different case numbers. Notice of clients did not apply to the current case. This is, was this, I mean, how many cases? Was this the one where he claimed that somebody went on his property went without consent?
So what happened was that Teresa Malcolm saw an electrical contractor out there.
Right.
And so the electrical contractor let her inside. So he's saying it was unconstitutional because the property owner was not the one that let her inside.
Right, okay, now I remember telling him that if whether it's a tenant or somebody on his property allowed the person to enter, in my opinion, that would be valid consent to get into the property because they were legitimately on the property. I also may have said that we're talking about an administrative proceeding where the full panoply of the Fourth Amendment may not apply. He said it did. I think the city attorney said it might apply as well, but there was testimony where there was consent given to get inside, and the initial final order was entered and signed by Rafael Suarez Rivas, Special Magistrate. Okay, that it may not be one of my cases, but I don't think it matters. That was done in May 18th, 2021. That's the final order. Then there is a supplemental order, code enforcement fine to impose for $3,150.
Who signed the lien? Was it you or Rafael?
No, I did. I signed the
Okay.
lien. The
That's
time-
probably where you heard about the Fourth
Right.
Amendment.
And actually, the time to file the appeal would have been
30 days after.
30 days after the initial order, but even if it was 30 days after the September 15th, 2021 order, let's assume for the sake of argument that he could have taken an appeal from that time period. His motion to set aside default judgment, where there's no provision that the town provides for rehearings and/or setting aside, as long as there was good service made, and there was, come up
That's
with
yours.
another conclusion that objection, it was in violation of Fourth Amendment. There's I went online here, I'm familiar with it, so board's authority to grant rehearing, this is an older Attorney General's opinion when there was no special magistrate, but 162 as amended years thereafter says that a special magistrate has the same powers as a code board. That was amended and put in there. So whether it's a code board or a magistrate, doesn't matter. In this instance, it was a magistrate. And advisory legal opinion, AGO 85-27, date is 1985, but I don't see anything more recent. Somebody asked, can there be rehearing or a motion to rehear the matter? And I'm looking at the paragraph. Thus, it appears that the Municipal Code Enforcement Board, which would appear here to be a magistrate, has the power to rehear or reconsider a matter which is the subject of one of its orders and take remedial action to modify its order. It is deemed necessary. However, such rehearing or reconsideration must be exercised before an appeal has been taken as provided in section 162.11 or the 30-day time period provided by that statute for taking an appeal. Clearly, this is well outside the 30 days. If this is a motion for reconsideration, but the basis of his argument, it appears, is that to be satisfaction of a case number which he erroneously thought, thinking the violation complied with no appearances made, now recognizes there are several case numbers, so he thought it was another case. That really ought to be denied. I don't see a basis for that, so that would be my notion. If you want to call him in to hear all this, the attorney, that's up to him. Not saying he didn't get a copy, he's saying he misread what he got with a case number. So I don't believe those would be legitimate grounds. Grounds would be no jurisdiction. He decided not to appear, so anyway, that would be my notion. Yeah, you might want to prepare an order that has been considered and denied, you know, I'll sign it, or Raphael or somebody will sign it. I don't. Yeah, exactly. Probably in order. Once you clear it with Melissa, if she says a letter is okay, then a letter, if she wants an order, tell me, and what you'll do is you'll give me, a copy. What I'll do is I'll just prepare a simple, the motion, whatever that's titled, motion to vacate in a rehearing or whatever it is, considered, and it's denied. Get Melissa's opinion since she's a city attorney, but that would be my notion. Other hearings, any other discussion of anything?
I had some clerical corrections, but I'm gonna have to revisit them later because I
Okay.
need to ask Nasli a few questions about them.
Great, and if you want me to sign something, just let me know. You can either email them and I'll mail them back, whatever your pleasure is, whatever you want to do.
I appreciate that. Thank you.
That's okay, that's what I'm here for.
And the next, just adjournment, or
Oh,
did you call that already?
Yeah, we'll adjourn, and I'll, see, this is February, April will be my next turn. I
Yes.
assume. Okay, great. Okay.
Did I send you that already?
For April? No, I think you do it on, you might,
Okay,
did you send, no, did you send out a, letter as to which, or an email as to which months I would take her here? You just do it alternating? You do it-
Okay.
I mean, alternating is fine with me, and if something happens and the other person can't make it, or I can't, we'll switch, the best we can in that department. There were no hearings in January, as I understand.
Okay.
Okay, all right. Okay,
So-
which is cool with me, so, all right.
So the meeting is adjourned at 12:40?
Yes, thank you.